to One Civil Law. Hope you're having a great day. So apparently it's going to be the last day for opinions for the term. That is what everyone is projecting. And there are 6 opinions supposed to come down. They started announcing opinions at 10 o'clock Eastern time at 27 minutes ago, and they're still only at opinion number 1. So we're going to try to cover these as they're happening. All right, so we got birthright citizenship right off the top of the gate. So you know it's a big day, people. It's a big day. We got birthright citizenship. Well, not really, but yeah, that's what they're calling it at least. So we're going to discuss this because it's a huge case. So let's go ahead and pull that up. Give me a second, please. I'm going to change the title of the stream. Besides birthright citizenship and other major cases. All right, cool. I'll change the title that way. Great, because that's what's going on. All right, cool. And then I'm going to make this a little bit, make this size. All right. So we're going to do this in as real time as as I can. All right. Everyone here? Are we live? Yes, great, excellent. All right. We turn our attention to the issue of birthright citizenship, or more properly, the issue of injunctions and national injunctions and scope of injunctions, which is a big enough issue as it is. We turn our attention to the case of Trump versus CASA on the application of the stay. This is dealing with injunctions. The plaintiffs here, individually, organizations, and states, filed 3 separate suits to enjoin implementation and enforcement of President Trump's order relating to birthright citizenship, basically saying in so many words, if you are here illegally and you have a child, the child does not become a U.S. citizen, among other things. The executive order identifies circumstances in which a person born in the United States is not subject to the jurisdiction thereof within the meaning of the 14th Amendment, or at least tries to, and thus would not be recognized as a U.S. citizen. The plaintiffs allege that the executive order violates the 14th Amendment's Citizenship Clause, Section 1, and Section 201 of the Nationality Act. In each case, the district court entered a universal injunction, and, call it by any other name, global injunction, national injunction, universal injunction. It goes by many other names, but whatever. An injunction barring the executive officials from applying the executive order to anyone, not just the plaintiffs, and perhaps more critically, everywhere, because that's the thing. And in each case, the Court of Appeals denied the government's request to stay the sweeping relief. The government argues the district courts lack equitable authority to impose universal global relief, and has filed 3 nearly identical emergency applications seeking partial stays to limit preliminary injunctions to plaintiffs in each case. The applications do not raise, and thus the court does not address, the question of whether the executive order violates the Citizenship Clause. So we're not trying to decide the merits of the citizenship issue today. What we're trying to decide is the scope of injunctions, which is arguably as big or perhaps even a bigger deal, depending on your point of view. Instead, the issue the court decides today is where, under the Judiciary Act of 1789, federal courts have equitable authority, or more to the point, federal district courts have equitable authority to issue universal global injunctions by any other name. Held, universal injunctions likely exceed equitable authority. Likely? All right, let's give this a shot. We're gonna try to split the baby. All right, let's give this a shot. Universal injunctions likely exceed equitable authority that Congress has given federal courts. The court grants government applications for a partial stay of the injunctions aired below, but only to the extent the injunctions are broader than necessary to provide complete relief with each planning a stand to sue. So we're not going to really decide the issue, I guess. We're punting, which, to be fair to the Supreme Court, I mean, they were hearing this under very constrained circumstances and time. But It's like, well, we're going to limit the scope of the injunctions in these three cases, but perhaps not speak as much to the issue as you or I might like. Our frustration will apparently continue a little bit further. The issue raised by these applications, whether Congress has granted federal courts, and more to the point again, federal district courts, authority to universally enjoin enforcement of an executive order plainly warrants this court's review. On multiple occasions and across administrations, the Solicitor General has asked this court to consider the propriety of this expansive remedy, and the justices themselves have talked about it, particularly Justice Scalia, or Justice Thomas has sort of alluded to it in multiple decisions. As the number of universal injunctions has increased over the years, so too has the importance of the issue. The government is likely to succeed on the merits of the claim that district courts lack authority to issue universal injunctions. Likely to succeed. The issuance of a universal injunction can be justified only as an exercise of equitable authority, yet Congress has granted federal courts no such power. The Judiciary Act of 1789 endowed federal courts with jurisdiction over all suits in equity, as does the Constitution itself. And still today, this statute is what authorizes the federal court to issue equitable remedies. Also, literally Article 3. This court has granted statutory grant encompasses only the sort of equitable remedies traditionally accorded by courts of equity at our country's inception. Universal injunctions are not sufficiently analogous to any relief available to the court in equity in England at the time of the founding. Yeah, so exactly when these universal, global, national, injunctions started, yeah, they didn't start the founding. 1960s, there's like one opinion in like the 1920s, which if you read it the right way, maybe, but like not really. But yeah, in any event, these sorts of scope, these injunctions of these scope were not known to law in the past. So that much is definitely true. Equity offers a mechanism for the Crown to secure justice where it would not be secured by ordinary existing process of law. The judicial prerogative of the king thus extended to those causes in which ordinary judges were incapable of determining. Eventually, the Crown instituted the practice of delegating the cases that came before the judicial prerogative to the chancellor for his sole decision. A judge by a different name. Sometimes we call them different things. So sometimes we didn't call them judge. Sometimes we call them something else. But a judge of equity, as opposed to a judge of law, when the courts were divided, which thank God for, the practice of law is less a problem today. The legal, although in some jurisdictions still a little bit, but yeah, the courts of equity and the courts of law used to be separate. In the United States, they're mostly combined. It makes my life a lot easier, I'll tell you what, but the legal principles are still separate, even though they're still heard by one court now, as a general principle. The general rule in equity is that all persons materially interested in the suit were to be made parties to it. Injunctions are no exception. They were sometimes sued to restrain actions of particular officers against particular plaintiffs. Of importance here, suits in equity were brought by and against individual parties, and chancellors, the judges for equity, were generally the remedies were generally party specific. Citing some case from England, which says you cannot have an injunction except against the party to the suit. In some under long-standing equity practice in England, there's no remedy remotely like a national injunction. Nor did founding era courts of equity in the United States chart a different course. And if anything, the traditional approach taken by federal courts cuts against the existence of the sweeping remedy. Consider Scott versus Donald, in which the plaintiff successfully challenged the constitutionality of a law on which state officials had relied to confiscate alcohol the plaintiff kept for personal use, presumably during Prohibition. Although the plaintiff sought an injunction barring enforcement of the law against himself and anyone whose rights were infringed and threatened by it, the court permitted only relief benefiting the named plaintiff. In the ensuing decades, the court consistently rebuffed requests for relief that extend beyond the parties. The court's early refusals to grant remedies to non-parties are consistent with party-specific principles that permeate the court's understanding of equity. Neither declaratory nor injunctive relief, the court instead can directly interfere with enforcement of contested statutes or ordinances except with respect to particular federal plaintiffs. In fact, universal, global, national, uniform injunctions were conspicuously non-existent for most of the nation's history. Their absence from the 18th and 19th century equity practice sells that question of judicial authority. Fair. While equity is flexible, the court's precedent emphasized that flexibility is confined within broad boundaries of traditional equitable relief. Because the universal injunction lacks historical predigy, it falls outside the bounds of the federal court's equitable authority under the Judiciary Act, or presumably Article 3, because it's the same language. Respondents' counter arguments are unavailing. In an effort to satisfy some cases' historical test, respondents claim that universal injunctions are modern equivalents of a decree resulting from a bill of peace, a form of litigation in the Court of Chancery. So they're going to try to say that there actually is a historical analog. They didn't call it an injunction. They called it a bill of peace, but arose by any other name, right? If it's the same thing, but we gave it a new label, no one will care because the label's not the thing, right? It doesn't matter what we call it. It matters what it is. So if we don't call it a bill of equity, if we don't call it a bill of peace anymore, but now we call it a global injunction, but it's the same thing. If it's the same thing, the fact that we gave it a new label, no one will care. So they're going to try to say, okay, this thing that we used to call a bill of peace is now something we call a universal injunction. It's the same thing, so we're all good. That's what they're trying to do. Let's see how that works. Respondents contend that the existence of the historic equitable device means federal courts have equitable authority to issue universal injunctions. The analogy, however, doesn't work. The court's not buying it. True, bills of peace allow courts of equity to adjudicate the rights of members of dispersed groups without formally joining them to a lawsuit through the usual procedure. Unlike universal injunctions, however, which reach anyone affected by executive or legislative action, bills of peace involved a group that was small and cohesive. So you might be able, it sounds like the court's saying maybe there's some opportunity to get past the parties, but not to the scope that it is now. All right. And unlike universal injunctions, which bind only the parties to the suit, decrees resulting from a bill of peace would bind all members of the group, whether they were present in the action or not. The bill of peace lives in a modern form, but not as to a universal injunction. So they're going to say, okay, yeah, we do have this thing called a bill of peace. We still have it, and we do have a different name for it now. It's just not a universal injunction. We call it something else. So we still have that thing. We have given it a new name. Again, the label's not the thing, but the universal injunction wasn't it. It's instead analogous to a modern class action, which in federal court is governed by Rule 23 of Civil Procedure. That makes sense, right? Because again, the Bill of Peace is for a small, defined group of people, and that's a class. That's a class. And we have rules for that, for a class action. And then the class is the party in the lawsuit. And so you're issuing an injunction for the party, which is the class. So that can affect potentially a lot of people, but it's still a defined group of people. And you have to go through that in sort of a class certification process, which, has some burdens to it. It has some burdens to establish a class. So there are rules for that. Cool. Rule 23 requires numerosity such that joinder is impractical. Joinder is just where we're like individually adding people as named parties. So that's joinder. But we can't do that because there's so many of them. Common questions of law or fact, typicality, which is that everyone in the class is more or less like everyone else in the class. Everyone in the class has been harmed in a particular way. They've all been harmed in at least a substantially comparable way, such that we can adjudicate this all at one go to everybody. And representative parties who adequately protect the interests of the class. The requirements for the Bill of Peace were virtually identical. So it's like, yeah, we do have this thing. We call it a class action now, not a universal injunction. Okay, fine. By foregoing a shortcut to relief that benefits parties and non-parties alike, universal injunctions impermissibly circumvent Rule 23's procedural protections. Respondents contend that universal injunctions, or at least these universal injunctions, are simply an application of the principle that a court of equity may fashion a remedy that affords complete relief. But complete relief is not synonymous with universal relief. It is a narrower concept, long embraced in the equitable tradition that allows courts to administer complete relief between the parties. Between the parties. Can you see me? Yeah, okay, great. So yes, the court can grant complete relief to the people that are there, right? Because they're parties, they're there. And in a class action, the conceit is everyone in the class is there, right? All 1,000 of us or 10,000 of us or 100,000 of us or whatever the conceit is we're all standing in the courtroom because the nature of the certified class. And of course, as you may or may not know, for class actions, you can opt out. So if you're unhappy with this, by the way, you don't have to be part of the class. You have the right to opt out and pursue your own remedy. So that, but if you're there, all 100,000 of us standing in the courtroom at the time, then, we can grant complete relief, make everyone whole, but only to the people that happen to be there. All right, that makes sense. To be sure, party-specific injunctions sometimes advantage non-parties, but they do so only incidentally. Here, prohibiting enforcement of the executive order against the child of an individual pregnant plaintiff will give that plaintiff complete relief. Her child will not be denied citizenship, and extending the injunction to cover everyone similarly situated would not render her relief any more complete. So, if you grant the injunction to the person, they're already made whole. Applying it to other people doesn't do anything to make that person more whole. They're already whole. There's nothing left to do for them. So individual and associational respondents are wrong to categorize universal injunctions as simply an application of complete relief principle. The inquiry is more complicated for state respondents because relevant injunction does not purport to directly benefit non-parties. Instead, the district court for the District of Massachusetts decide universal injunctions are necessary to provide the states itself complete relief. As the states see it, their harms, financial injuries, and administrative burdens flowing from the citizenship-dependent programs cannot be remedied without a blanket ban on enforcement of the executive order. Children often move across state lines or are born outside their parents' state of residence. Given cross-border flow, the states say a patchwork injunction would prove unworkable for provision of certain benefit funds. So the states say, well, wait a second, we're a party. We're a party. The state of Texas, the state of Mississippi, the state of New York, we're a party. And if you do this piecemeal, that's going to provide a lot of administrative burden to us because, well, people move between states and children are born in states in which they don't currently live. And sometimes their parents are in a different state than the children are, depending on details. And this is just going to become a whole nightmare. How are we supposed to deal with this? So to grant us complete relief, we need to understand the field for everybody because it's an administrative nightmare. Okay. The government retorts that even if an injunction is designed to benefit only the states, it is more burdensome than necessary to the asserted harm, and that the narrow relief is appropriate. The court declines to take up these arguments in the first instance. The lower court should determine whether a narrower injunction is appropriate, so we leave them to consider these and any other related arguments. Well, that kicks the issue down the pipe, right? So to the extent the state itself is a party, we're not going to answer the question as to the universal injunction issue. Because how do we make the state whole? We're not going to issue that. We're not going to decide that issue today. So that's a bit frustrating, but at least it only is frustrating where the state itself is an entity, which won't be in many of these things. So it solves many of the problems or clarifies many of the grounds, if not everything. So the relief the Supreme Court grants me today in deciding this issue is not complete, but it's still a lot. So I'll take what I can get for the moment, at least. Respondents defend universal injunctions as a matter of policy. The government advances policy arguments running the other way. As with most questions of law, the policy pros and cons are beside the point. Under courts' well-established precedent, because universal injunctions lack a founding era forebearer, federal courts lack authority to issue them. This is still a pretty big deal. This is a major change of law. I guess states will try to find ways to get more involved in more lawsuits, but this is still a pretty big change, despite it. So, all right. To obtain interim relief, the government must show it's likely to suffer irreparable harm absent a stay. When the federal court enters a universal injunction against the government, it improperly intrudes on a coordinate branch of the government and prevents the government from enforcing its policies against non-parties. Anytime a state is enjoined by the court from effectuating statutes enacted by representatives of the people, it suffers a form of irreparable injury. The court's practice also demonstrates that applicant need not show it will prevail on the underlying merits when it seeks to stay on a threshold issue, because that is not the standard for injunction. You don't have to show that you will succeed, but you do have to show likelihood of success, which is not the same thing. The government here is likely to suffer irreparable harm from the district court's entry of injunctions that likely exceed the authority conferred by the Judiciary Act, and the balance of equities does not counsel against awarding the government's interim relief. A partial stay will cause no harm to respondents because they will remain protected by preliminary injunctions to the extent necessary and appropriate to afford them complete relief. When a court concludes that the executive branch has acted unlawfully, the answer is not for the court to exceed its power to. Fair. The government's application for partial stays of preliminary injunctions are granted, but only to the extent the injunctions are broader than necessary to provide complete relief. Justice Barrett delivers the opinion of the court. That's slightly surprising. I mean, they gave Justice Barrett a big boy decision. Wow. I mean, they gave Justice Barrett a big boy decision. Big boy decision. It's like, you would think this would be written by like the Chief Justice or something, but it's being written by Barrett. I'm like, wow, okay, damn. I'm not sure if they're trying to make a point or something, but shit. Justice Barrett delivers the opinion of the court in which Roberts, Thomas, Alito, Gorsuch, and Kavanaugh join. Thomas concurs in which Gorsuch joins. Alito files a concurring opinion in which Thomas joins. Kavanaugh files a concurring opinion. Sotomayor dissents in which Kagan and Jackson dissents in a 6-3 opinion, which I suppose is not surprising. Well, friends, the law just changed in a fairly major way. Universal injunctions are dead, except maybe if the state is a party, possibly. We'll get back to you on that. But the Supreme Court seems to not even really support it then, but they're not completely answering the question. So this is a very big deal. This is an incredibly big deal. And actually, it's even more expansive than it had to be, because not only is it not like, okay, the district court only has power in their district, right? Because that would be one thing, right? The district court can only issue an injunction that covers their district. It's even worse than that for the injunction, friends, because unless the state itself is a party, you can't issue an injunction against non-parties. That is a huge deal. The scope of this deal is hard for me to fully convey to you how big a deal that is. You're talking about every lawsuit now by anybody, whether Republican or Democrat, liberal or conservative, suing the EPA or suing the CDC or suing anybody and trying to get universal relief, trying to get relief for everybody in a non-class situation. Again, let's take apart class action. If this is a certified class action, the conceit is everyone in the class is there, right? That's the conceit. Everyone in the class is a party. So taking away that situation. But what you have now is a situation that unless, like the state of Texas, the state of Connecticut, the state of California, unless the state itself is a party, then universal injunctions are dead. Republican or Democrat, liberal or conservative, for or against governmental action by, EPA, CDC, or whatever other governmental agency you want to throw into this sentence, FCC or anything else, right? And now it is worth noting, of course, that the legal principles that are provided by the court still have teaching effect. They just don't have binding effect as to the parties, but they might have legal, but the law itself might be binding, even because, for example, if the Ninth Circuit renders a decision right? And they interpret a legal principle, that legal principle would apply to any person in a future proceeding. So it still could apply in that sense, but it won't apply on its own terms. So this is still a pretty big boy decision and a pretty big change of law. And it sounds a lot like the Supreme Court wants to kill it, even if the state is a party. But they're not quite deciding that today, which, given the condensed time frame, makes sense. But yes, all those things. And yes, Second Amendment stuff too. Every cause of action, all the causes of action. Yes. You want to sue the EPA, you want to sue the CDC, you want to sue the ATF, you want to sue the, Federal Election Commission, Federal Communication Commission, you want to sue the FDA, right? For whatever thing you want to sue them for. Yes, that's the nature of the thing. You want to sue for or against them doing something. You want to sue because you're a liberal or conservative. You want to sue them because you like government action or you don't. Yeah, universal injunctions are dead. That's the deal. And so that's it. And that's the way it goes. So all those things. Can non-citizens be a class? Many of them could be, sure. Yes, because, well, whether they are citizens or not is somewhat the issue in dispute. But yes, even non-citizens, to the extent that they can bring suits, which you don't necessarily have to be a citizen to bring a lawsuit, depending on what lawsuit you're bringing. So yes, to the extent that non-citizens would be a party, then yes. Yeah, all those things. So that's all those things are happening. That's a pretty big deal. That's a very, very big deal. So I'm going to have to do a video on that separately or something to try to explain that in some more detail, because that is a huge ass deal. All right. So what else we got today? We got some other stuff today. This is going to be a long morning, people. Apparently Jackson wrote, "With deep delusionment, I dissent." Wow, the adjectives are getting more real, ma'am. All right, let's see what else we got today. All right, I don't remember this case off the top of my head, but maybe I recognize it as it goes. All right. We turn our attention to the case of Kennedy versus Braidwood Management, or Kennedy in his capacity as Secretary of Health and Human Services, I should have said. Apologize. The Health and Human Services versus Braidwood Management. Let's read this case. In 1984, the Department of Health and Human Services created the United States Preventative Services Task Force, a body that formulates evidence-based recommendations regarding preventative health care services. Congress codified the task force in 1999, establishing as an entity within the Agency for Healthcare Research and Quality inside of HHS's Public Health Service. The task force currently consists of 16 volunteer members appointed by the Secretary of HHS to staggering 4-year terms. Before 2010, the task force recommendations were purely advisory. The Affordable Care Act of 2010 changed this by requiring most health insurers and group health care plans to cover, without cost sharing, those preventative services that receive A or B readings from the task force. So we've got some body inside the government that decides whether or not certain preventative care is important and stuff. And if they give it a rating of A or B, whatever that means, then healthcare companies that are covered by the Affordable Care Act have to provide coverage for that, essentially at no extra cost, or they have to roll it into the, All right, anyways, pressing on. The act also amended the government statute to describe the task force as independent, whatever that means, and provide that members and their recommendations shall be independent and to extent practice not subject to political pressure. So we want to try to have a body that is not subject to the president. Okay, good luck with that plan. Plaintiffs, individuals, and small businesses who object to the Affordable Care Act's preventative services coverage requirements because money, sued in federal court. The lead plaintiff, Braidwood Management, runs a health and wellness center offering insurance coverage to its approximately 70 employees through a self-insured plan. Plaintiffs argue the task force members are principals, officers. Oh boy, this gets to an appointment clause, man. We're doing an appointment clause today, man. Damn, we're going all the geek. We're going super duper geek, man. We're doing an appointments clause. Let's go, baby. Let's go. Appointments clause, baby. All right. Plaintiffs argue the task force members are principal officers under the appointment clause, which would then mean that they must be literally appointed by the president themselves with advice and consent of the Senate, not by the secretary, which would be true. So we are trying to argue that members of this task force are principal officers. They're on the same tier, if you like, as the secretary himself, right? That's what we're trying to argue. They're like cabinet level officials. Cabinet level officials have to be named and appointed by the president. Certain lesser officials don't have to be. So we're trying to say the task force has been secretly part of the cabinet the entire time, basically. Okay, let's give that a shot. That's gonna be fun. The district court agreed, recognizing task force are removable at will by the secretary, but concluding they are principal officers because they have no superior who supervises and directs them. It sounds like it. Did Congress do a stupid? Congress can't do a stupid. They know how to write laws. They didn't do a stupid. While the government appeal was pending, the secretary in June 2023 ratified existing appointments made by some other director and began personally appointing task force members. So the secretary of Health and Human Services, kind of noticing the problem, in something of a panic, be like, okay, I'm going to solve this problem by appointing them myself. So I'm going to try to appoint them now and try to get past this issue. Okay. The Fifth Circuit affirmed the district court, holding that while task force members are removable at will, they are not inferior officers because they cannot be independent and free from political pressure while simultaneously being supervised by a political appointee. Did Congress do a stupid? Did Congress do it dumb when they wrote a statute? Surely not. Surely Congress didn't do a stupid when they wrote this statute. Held. Task force members are inferior members who appointment by the Secretary of HHS is consistent with the appointment clause. I think the Supreme Court just saved your ass. I think the Supreme Court just saves Congress's ass. All right, that's fine. The appointment clause in Article 2 specifies how officers of the United States must be appointed, dividing all officers into two classes. Principal officers must be appointed by the president themselves with advice and consent of the Senate, in the same way that the Secretary of Health and Human Services would be appointed. Inferior officers likewise may be appointed by the president and the Senate, but Congress may also, by law, vest their appointment in the president alone, in courts of law, or in the heads of the department. So if an inferior officer, maybe someone else can do the job, because the Constitution says they can. Principal officers encompass at least department heads who report directly to the president, such as the secretary. Inferior officers are those whose work is directed and supervised at some level by others who are appointed by presidential nomination with advice and consent of the Senate. Task force members are inferior officers because their work is directed and supervised by Secretary of HHS, a principal officer, through two main sources of authority. The Secretary's authority to remove task force members at will provides a powerful tool for control. An officer's presumed desire to avoid removal generally creates here and now subservience. Here, the Secretary has power to appoint task force members, and no statute restricts removal. Therefore, the Secretary may remove task force members at will, enabling him to supervise and direct them. I think the Supreme Court just saved your ass, Congress. Try not to be dumb next time. Beyond at-will removal, The Secretary has statutory authority to directly review and block task force recommendations before they take effect. Several statutes give the Secretary general supervisory authority over public health service within which the task force is housed, as well as rulemaking authority with respect to the Affordable Care Act's provisions. During minimum 1 year interval before recommendations become binding, the Secretary can use his supervisory authority to direct the task force recommendations he disagree with not be in effect and therefore not be binding or established through federal rulemaking. So the Secretary can just come in and be like, nah, right? So the task force, publishes their thing. And as long as the Secretary does it within a year, he can just be like, no, that's okay. I don't want to do that. So, fine. Task force members, therefore, have no power to render a final decision on behalf of the United States unless they're permitted to do so by the Secretary. The conclusion that the task force members are inferior officers follows a fortiori from this court's precedent. In Edmund, the Coast Guard judges who were removable at will and whose decisions could be reviewed and reversed were deemed inferior officers, even though superiors could not influence individual proceedings. Like those judges, task force members are removable at will, and their decisions can be reviewed and overruled by the Secretary. In Free Enterprise Fund versus PCAOB, members removable at will by the SEC were inferior officers, even though they were empowered to take significant enforcement actions largely independent of the SEC as a whole. In Atherex, administrative patent judges, HALA, whose decisions were removable but removable only for cause, were inferior officers. If patent judges, subject only to review authority, were inferior officers, task force members subject to both at-will removal and inferior authority are clearly inferior officers. Braidwood's arguments against inferior officer status fails. The independence provision in 9299B4 states that task force members shall be independent and, to the extent practical, not subject to political pressure, does not create for-cause removal protection. To displace the default at-will removal, Congress must use very clear and explicit language mere inference will not do. I think the Supreme Court tried to save your ass from the stupid. I think they came in and saved your bacon. You should be thanking the Supreme Court right now, Congress, because you did it dumb, but the Supreme Court is here to help you out of your jam. You should be thanking them. But independent is best read to mean task force members must not be unduly influenced by outside professional affiliations. Oh yeah, that's definitely what that means. Okay, sure. Even if the independence provision meant some insulation from the Secretary when practical, this would only affect the formulation of recommendations, not the Secretary's authority to review them before taking effect. This mirrors the almost universal model of adjudication in the executive branch, where inferior officers make independent initial decisions subject to review by politically accountable authority. The Secretary's inability to compel task force members to issue a particular A or B recommendation does not undermine the inferior officer status. This court has not suggested a principal officer must be able to compel subordinate officers to take affirmative acts that for them to qualify as inferior. He can't force them to do an A or B rating, but what does it matter? Because he can just be like, no. So the board is like, we want to give it an A rating. The Secretary is like, I don't like A. And the board's like, well, you can't make us. And the Secretary is like, I guess I can't. But you know what I can do? How about just no? So I can't make the A a B, and I can't make the B presumably a C. I can't do that, but I can be just like, nah. So how about F? So I guess, it all works out in the end. All right. In Free Enterprise Fund, the SEC lacked power to require PCAOB to start investigations, yet PCAOB members were inferior officers. Similarly, in Edmund and Atherex, superiors could not compel individual decisions. When Congress wants to create an independent agency, it generally does so by explicitly conferring for-cause removal protection on agency leadership, and usually couples that protection with express presidential nomination and Senate confirmation requirements. The statute establishing the task force contains none of this customary language. Congress has by law vested appointment authority in the Secretary of HHS through two steps. First, the 1999 statute governing the task force gives the director of the sub-agency the authority to convene a task force to be comprised of individuals with appropriate experience. Congress need not use magic words to confer appointment authority, and around the time of the founding, appoint was synonymous with allot, assign, or delegate. In the absence of statutory provision that more explicitly confers appointment authority, the AHRQ director, the sub-agency director, power to convene is naturally read to include the power to appoint. Man, they really went out of their way to save Congress's ass. Second, Reorganization Plan 3 of 1966, ratified by Congress in 1984, transfers to the Secretary all functions of the Public Health Service and its officers, employees, and agencies. The sub-agency director is an officer of the Public Health Service, so the reorganization plan transfers the sub-director functions to the Secretary. After statutory codification of the task force in 1999, those powers of the Secretary included AHRQ's director, a power to appoint the task force. Therefore, by virtue of the 1984 Act ratifying reorganization plan and 1999 plan conferring appointment authority, Congress vests the power to appoint task members in the HHS. Braidwood's argument that Congress is not properly vested appointment authority in the Secretary fails. Braidwood first claims the 1999 statute used to convey does not confer appointment authority, instead agnostic about who should appoint task force members. Braidwood's interpretation would create a bizarre scheme where Congress was entirely indifferent about who would appoint members, making legally binding health care recommendations. Braidwood's next argument is even if the director has appointment authority, the reorganization plan does not transfer the power to the Secretary because it applies only to the director's functions as of 1966. This frozen in time reading finds no footing in the statutory text or common sense. The plain language, all functions, most naturally means ongoing authority. The Secretary has properly exercised appointment authority since June 2023. Kavanaugh delivers the opinion of the court in which Thomas, Alito, and Gorsuch dissent in a 6-3 opinion. Yeah, I'm not particularly surprised Gorsuch dissented because Gorsuch, of course, you know, is my boy. Holla, Gorsuch. Gorsuch is my boy, and he's not going to go out of his way to read the statute any other way than the way you wrote it. So I appreciate that. Because that's all good. Yeah. All right, I'm starting a formal Q&A because that's the thing I can do. I'm starting a formal Q&A, and that way, if you have questions regarding any of the cases, whether the case we just did or this case, either case, if you have questions about the birthright citizenship injunction thing, or if you have questions about this, or any of the other cases we're going to cover today, you can put them in the questions box, and that way I'll see them later. So make sure to put them in the questions box, and that way I'll know they exist, and huzzah. Or super chat, that would also be fine. But I'm here to help. All right, what else we got today? That one was very geeky. And somewhat funny. All right, what else we got today? All right, we got LGBT Storybook Hour. Okay, this one's good. We're doing spicy today at the Supreme Court, guys. Do you guys like spice? Are you in maximum spicy? Are you maximum spicy, guys? You got to strap in, man. You got to strap in for today's issue. Okay. Schools would like to read your young children, and by young we mean like kindergarten, potentially. The schools would like to read your young children books with significant LGBTQ themes. They would like to read them books at Storybook Hour that have significant LGBTQ themes / doctrine / indoctrination / whatever. Some parents have a problem with this. Okay. I think this is Maryland. The Maryland school district said parents can't choose. So many school districts are like, okay, no, parents can opt out. And it's Montgomery. I think it's Maryland. Maryland's like, no, parents can't choose. You have to. If they're going to public school and they're in kindergarten, we are going to read them the LGBTQ book, during Storybook Hour with the strong LGBTQ themes, and you can't stop us. We're going to read it to the kids. You can't opt out. The kids can't be excused from class. They have to sit there and read and they have to enjoy the LGBTQ book no matter what. That's what happened. Okay, Maryland went hardcore. They went super duper hardcore. Okay, they went all the way in the paint. Okay, so for today's issue, if you as a parent have a problem with this, is it okay for your kid to not be there and not do the LGBT? Is that okay? Is it okay for you to be like, I don't really want them to be there during the LGBTQ? Is that okay? Can you opt out? Can you opt out? Let's find out. What is the law? We turn our attention to the case of Mahmoud versus Taylor. During the 2022-2023 school year, the Montgomery County Board of Education introduced a variety of LGBTQ inclusive texts. And incidentally, by the way, we read these texts previously because if they were submitted on the record, because of course they were. So we have previously read these books. If you like, we can read them again because they're on the record. I'll have to dig them up, but I can dig them up because they're on the record, because of course they are. So I can go read them because they're in the court filing. If you'd like, we could read the books they were reading to the youngs again. They were fun / disturbing / horrible. Those texts include 5 LGBTQ plus books, storybooks approved for, as I mentioned, kindergarten. I am not making this shit up. I am not lying to you. When I tell you they were reading the LGBTQ books, were you doing a hyperbole, Kurt? Were you doing a hyperbole? Were you doing a parade of horribles? Were you making a funny? No, I wasn't doing any of those things. This is really happening. This is real life, people. This is really happening. And you can't opt out. Your 5-year-old has to sit there. You can't excuse them. They have to sit there during the LGBTQ book. I am not making this shit up. This is happening. All right. For the students in kindergarten through 5th grade, with storylines focusing on sexuality and gender, that's one way of putting it. When parents in Montgomery County sought to have their children excused from instruction, like, maybe they could go to the library or something while you're, reading the stupid. The board initially compromised with parents by notifying them when the LGBTQ books would be taught. So initially, they allowed the children to be excused. Initially, they're like, yeah, you can excuse your children, but then they're like, nah. That compromise was consistent with the board's guidelines for respecting religious diversity, which professed a commitment to making reasonable accommodation for religious beliefs and practices. Less than a year later, however, it rescinded the opt-out. Oh, never mind. Yeah, no, never mind. You can't excuse the 5-year-old from the LGBTQ book. Not so much for you. No opt-outs for anybody. Everyone gets to enjoy the LGBTQ books with the sexual themes for the 5-year-old. Great. Among other things, the board said it could not accommodate the growing number of valid opt-out requests, which alone should tell you you have a problem, right? The board's like, we can't accommodate all these opt-out requests. There's just too many of them. Too many parents don't want their kids to be exposed to these books. We can't accommodate all these kids. Now, that really should be a clue to you. Maybe you're doing something wrong. If so many parents are opting out, this is creating a burden for you. Maybe that's a clue that maybe what you're doing is not right. But the school board is having none of this. They're not having any of this. They believe it's right, and they're going to be damned if you try to tell them any differently. I'll tell you what, man. So they're like, we can't accommodate all these kids. There's just too many of them. Petitioners here are a group of individual parents and unincorporated association of other interested parties. The individual parents come from diverse religious backgrounds and hold sincere views on sexuality and gender, which they wish to pass on to their children. Faced with board decision to rescind the opt-outs, petitioners were not pleased, and they filed a lawsuit in the District of Maryland. It was Maryland, huzzah. Among other things, they asserted that the board's no opt-out policy infringed on the parents' free exercise of religion. They rely heavily on a case called Wisconsin versus Yoder, in which the court recognized that parents have a right to direct the religious upbringing of their children, and this right can be infringed by laws that pose a very real threat of undermining religious belief and practices that parents wish to instill. So we still have freedom of religion in this country, and you're allowed your religion, you're allowed your religious beliefs, and the government isn't allowed to undermine that and stuff. Because, that would be bad. Okay. Petitioners here sought preliminary and permanent injunction prohibiting the school board. The district court denied relief, and the divide panel of the Fourth Circuit affirmed. So the Fourth Circuit Court of Appeals, based in Richmond, Virginia, the Fourth Circuit Court of Appeals is like, nope, mandatory storybook hour. You can't opt out for religious reasons. You can't opt out for any reasons. The 5-year-olds will be indoctrinated, says the Fourth Circuit Court of Appeals in Richmond. Holla. How you doing over there? Not so good. What does the Supreme Court have to say about all this? Are they cool with that? Are they cool with the mandatory gay storybook hour thing? How are they feeling? All right. Held, parents challenging the board's introduction to the LGBTQ plus inclusive storybooks, along with decision to withhold opt-outs, are entitled to a preliminary injunction. Oh, the parents win. Okay, yeah, I mean, the parents win. Kind of saw that one coming, right? The dissent on this is going to be amazing. You know there's a dissent. You know there's a dissent. You know it's probably written by, who is it written by in this time? It's probably written by Sotomayor, and it's going to be, the gnashing of teeth is going to be incredibly, incredibly real. The dissent on this has got to be amazing. What do you mean? What do you mean they won't let us read the LGBT? They won't force the students to read. What do you mean they won't do it? Right, the dissent on this has got to be real. All right, pressing on. The parents assert that the board's introduction to LGBTQ plus inclusive storybooks combines with its decision to withhold notice and opt-outs. By the way, you got to tell your friends to pop over here on Uncivil Law. I know there's 840 of you over here, but with all due respect to like everyone who's not here, people have no fucking clue. Like, I appreciate that people want to tune in for Karen Read, but how are there not 30,000 people right here right now? Like, this is, I don't understand. I don't understand how people are not like drawn in by this. This is huge, huge. I mean, Karen Read is important and all, but in the end, it is one person. I mean, you know, not to say that, you know, that one person isn't important, but it's one person. This is like all the school kids everywhere, and all the birthright citizen everywhere, and all the injunctions everywhere. I mean, dude, man, come on. How is this? How are there not 30,000 people here? Get your friends over here. They're missing a lot. Damn. The parents assert that the board's introduction of the LGBTQ plus inclusive storybooks combines with the decision to withhold notice and opt-out unconstitutionally burns their religious exercise. At this stage, the parents seek a preliminary injunction that will permit them to have their children excused from instruction related to the storybooks while the lawsuit proceeds. To obtain that form of preliminary relief, the parents must show they're likely to succeed in the merits, they're likely to suffer irreparable harm, the balance of equities tips in their favor, and an injunction would be in the public interest, which is the same 4-factor test it always is, every single time, and sometimes it's phrased a little differently because sometimes the circuits have slightly different phrasing for the 4-factor test because they want to be a little different. I don't know. They can't just all use the same language. So sometimes they use different language, but it's all the same. I wish they would just pick the one thing because it's all the same. But, you know, those circuits sometimes they just got to be a little different. I don't know, man. But anyways, this 4-factor test should look really, really familiar, even if the language looks slightly different than you're used to seeing. Because, you know, again, call it whatever you want, put a different label on it, use different words, but it all amounts to the same in the end. So it should look really, really familiar. The parents have made such a showing. Parents are likely to succeed on their claim the board's policies unconstitutionally burn their religious exercise. The court has long recognized the rights of persons to direct the religious upbringing of their children. Those rights are violated by government policies that substantially interfere with the religious development of the children. For people of faith, there are few religious acts more important than religious education. Fair. And the practice of educating one's children in one's religious beliefs, like all religious acts and practices, receives a generous measure of constitutional protection. Well, that is somewhat underselling it, right? Yeah, you know, it's like, you know, that's somewhat underselling. You know, that freedom of religion thing? Yeah, we think that should be interpreted somewhat generously. We think maybe freedom of religion is okay. And it's all right. And, you know, perhaps a slightly more generous interpretation. Freedom of religion is interesting too, because it's an exception to a rule. that I get. So we get to geek out on legal stuff because that's why we're here, right? So as long as we're here to learn something of legal value, normally you can't sue under what's called like taxpayer standing. So normally you can't sue because you don't like, just because you're just a taxpayer. That's why it's called taxpayer standing, right? You can't sue the government for doing something you don't like just because you're a taxpayer and you pay taxes and you don't like it and your taxes are being misallocated, blah, blah, blah. That is not enough for standing, right? You have to show a more direct harm. There's an exception, though. There's an exception. There's an exception. Of course, there's an exception. Why wouldn't there be exceptions? Because it's law, right? If it's free exercise, if it's the free exercise clause, there is taxpayer standing. So you can sue without any other injury just because you're a taxpayer, because freedom of religion. That's how generous it is. And it stands alone in this respect. It is the only clause of the Constitution in which that's true. So when they say generous, they mean like, yeah, to the extent that we're granting people special rights because of religion. That's how seriously we're taking it. So they're not getting around. The Constitution protects, for example, a parent's decision to send his or her child to a private religious school. Yeah, you can do that. That was a case once. I mean, you know, that was a case once. There was a state somewhere that said, okay, we're going to have mandatory public education. And also, when we said mandatory, we meant like mandatory. And there was a parent who's like, you know what? I really don't want my kids to go to public schools. I really prefer they go to a Catholic school, I'm going to assume. I really prefer they go to a Catholic school or a Jewish school or whatever. And I'm more than happy to pay for it, you know, myself. I'm more than happy to pay for it out of my own pocket. And you know, you can have the state curriculum and they'll get all the same education that, you know, that the state believes is important. But I'd also like them to go to the religious school because, you know, they're going to have explicitly religious classes. One of the classes they're going to do is going to be like Bible study, where they're going to learn about the Word of God and stuff. You know, not so much in a public school, but, you know, I'd like them to not be in public school and go to the private school. Is that okay? And some state once said no. Some states said no private education for you. When we said mandatory public education, we meant it. Everyone has to come to our schools. Everyone. The Supreme Court had a problem with that previously. So, okay, yeah. So yes, parents, you can in fact send your kids to a private religious school if you want. That's okay. In case you needed to know that, there's a case that tells you that. So that's great. And the court has recognized limits on government's ability to interfere with a student's religious upbringing in a public school setting. In West Virginia Board versus Barnett, for example, the court held that the policy requiring public school students to salute the flag could not be enforced against Jehovah's Witnesses, which incidentally was pretty funny because the Supreme Court had like 3 years earlier said they could be forced to and changed their mind. I don't know if it's the fastest the Supreme Court's ever changed its mind, but it's got to be close. Right? Because like 3 years earlier, the Supreme Court said, yes, you can force all the students, religious or otherwise, to stand up and salute the flag. You can make them. And then 3 years later, they're like, oh, no, wait, that was dumb. And no, they can opt out. That's okay. So sometimes the Supreme Court changes itself, and that was a pretty fast turnaround. Barnett involved an egregious kind of direct coercion, a requirement that students make an affirmation contrary to the parents' religious beliefs. In Yoder, the court held a free exercise clause also protects against policies that impose more subtle forms of interference with religious upbringing. There, the court considered a compulsory education law that would place Amish children in an environment hostile to Amish beliefs, which would face pressure to conform contrary lifestyles. So again, like, you know, all the Amish children, we want to go to public school, and the Amish are like, but, you know, we don't really like technology and stuff. It's one of our things. We're not really big into the technology. And they're like, nope, all the Amish children have to come to our schools. No Amish opt out for you. Supreme Court had a problem with that one too. So they were cool. They weren't cool with the indoctrination of the Amish. They weren't feeling it. The court has concluded that such laws substantially interfere with religious development of Amish children and therefore carry with it the precise kind of objective danger to free exercise of religion that the First Amendment was designed to protect. The board's introduction of the LGBTQ plus inclusive storybooks, combined with the decision to withhold notice to parents and forbids opt-outs, substantially interferes with the religious development of petitioners' children and poses the kind of burden on religious exercise that Yoder found unacceptable. These books are unmistakably normative. In other words, they're trying to tell a story, or more to the point, they're trying to set a norm. So they are literally normative because they're trying to establish a norm. The books are trying to say this is normal, therefore they're normative. Yeah, right. So exactly. Where were we? Okay, they're designed to present certain values and beliefs as things to be celebrated and certain contrary beliefs and beliefs as rejected. Take, for example, the message sent by the book concerning same-sex marriage. Many Americans advocate with the utmost and sincere conviction that by design precepts, same-sex marriage should not be condoned, citing Obergefell, which said exactly that. That group includes each of the parents in this case who might not be thrilled with the LGBTQ or gay marriage, which you're entitled to an opinion, just generally speaking, of course. Like, freedom of speech is still a thing too. You could oppose gay marriage for non-religious reasons, I guess. There's probably a secular humanist argument to be had against gay marriage. So you could oppose it for just freedom of speech reasons. Also because of religious reasons. That'd be fine. And incidentally, by the way, even if there weren't a secular humanist reason to support it, you could still oppose it just because you're an asshole. You're allowed to have opinions just because you're an asshole. Opinions can't be wrong. The storybooks, however, are designed to present opposing viewpoints to young, impressionable children against the 5-year-olds, who are likely to accept without question any moral message conveyed by their teacher's instruction. That's definitely a strong possibility. The teachers want to trans your kids, and they were trying really, really hard. They're trying really hard. The storybook presents same-sex weddings as an occasion for great celebration and suggests the only rubric for determining whether a marriage is acceptable is whether the individuals concerned love one another. The storybooks similarly convey normative, in other words, establishing a norm, on the subject of sex and gender. Many Americans, like the parents in this case, believe biological sex reflects divine creation. That sex and gender are inseparable. That's what I think. I actually think they're the same thing. Or I also think that gender doesn't really exist. One of the two. So either sex, that's what I think. I'm not even kidding. I think either sex and gender are the same or gender doesn't exist. That's what I think. So maybe you think that opinion's stupid, but then again, I'm allowed stupid opinions and I have freedom of speech to say it, so bite me. And that children should be encouraged to accept their sex and live accordingly. The storybooks, however, suggest it's hurtful and perhaps even hateful to hold the view that gender is inextricably bound, which incidentally, by the way, even if it were hateful, you're allowed to have hateful opinions too. So even if it were a hateful opinion, you're allowed to have hateful opinions. You're allowed to hate people if you want. That's what freedom is. Do I have to explain this to people? Apparently I do. The United States does not have laws against hate speech. Hate speech is legal. Moving on. Like compulsory high school education considered in Yoder, these books impose upon children a set of values and beliefs that are hostile to their parents' religious beliefs. And the books exert upon children a psychological pressure to conform to their specific viewpoints. The books therefore present the same kind of objective danger to exercise religion that the court identified in Yoder. None of the counter arguments raised by the board, the courts below, or the board's amici gives any reason to doubt the existence of the burden of the religious exercise here. The court does not accept the board's characterization of the LGBTQ plus exclusive instruction as mere exposure to objectionable ideas or lessons in mutual respect. I'm laughing because it's stupid. They tried to reframe it. I mean, I guess you got to give them points for trying in some respects, but they tried to reframe it. It's not that we're trying to indoctrinate them. We're just trying to teach mutual respect or something. Blah, 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 blah. Okay, great. The storybooks, the Supreme Court's not buying this. The Supreme Court's unmistakably convey a particular viewpoint about same-sex marriage and gender. They sure do. And the board has specifically encouraged teachers to reinforce this viewpoint and reprimand any children who disagree. It certainly did, right? So not only like the board published, I forget exactly what they called it, but they published like guidelines for the teachers, or like a frequently asked questions for the teachers, or they published something for the teachers that, and we can go back and read what it was in the complaint, but it's like, you should, if a child says like, if the 5-year-old were actually able to stand up and say whatever the 5-year-old equivalent of would be of, you know, I don't support gay marriage, whatever that would be for the 5-year-old to say that. The guidelines, FAQ, whatever, published by the school board to the teachers in the instructional plan, or maybe it was the program to teach the teachers, whatever. In any event, they told the teachers to like correct the child, reprimand the child, and basically tell the child was wrong in so many words. So I'm not sure how this is just teaching mutual respect as opposed to your ideas are wrong and indoctrination, but you know, the school board's gonna try what it's gonna try. This goes beyond mere exposure, you think? Regardless, the question in the case of this kind is where educational requirement or curriculum at issue would substantially interfere with religious development of a child or pose at least a very real threat of undermining religious beliefs and practices parents wish to instill in children. Whether or not a requirement for a curriculum could be characterized as exposure is not the touchstone for determining whether the line is crossed. The board's reliance on the court decision in Bowen versus Roy and Lynn versus Northwest is likewise unpersuasive. In those cases, the court held that free exercise clause cannot be understood to require the government to conduct its own internal affairs in a way that comport with religious beliefs of particular citizens, which isn't what these parents are asking for. At least, right? It's not for the moment. They're not asking the instruction to change. They're asking to be exempted from the instruction. So you can't necessarily make the government do, you can't necessarily make the government teach what you want to teach, not for the least of reasons that, you know, different people have different beliefs and that just doesn't work. But that's not the issue. Right? Okay, even where the conduct of such internal affairs might result in incidental interference with an individual's spiritual activity, that principle has no application here. The government's operation of public schools is not a matter of internal affairs akin to the administration of Social Security or selection of filing cabinets. Did someone try to bring a free exercise clause case because they didn't like the filing cabinets the government chose? If that case exists, that'd be amazing. But even assuming that you have a religious belief relating to filing cabinets, I'm sorry, you can't make the government pick the filing cabinets you like best. You are more than free to have whatever filing cabinets you want in your own home, however. Lord have mercy. In this situation, it implicates direct coercive interactions between the state and young residents. The court below erred in dismissing the court's decision in Yoder. This court has never confined Yoder to its facts, and there's no reason to conclude the decision is sui generis, which basically means self-generating, which means the case just kind of, you know, that's basically that's basically the but this one time though. Sui generis is but this one time though, usually, right? This case is so unique. This case is so unique. We need to come up with a decision just for this. Yeah. Yeah. Sui generis is dangerous. If you're a court and you're thinking about writing, you know, this case is sui generis, please reconsider, because it almost never ends that way. It's just one time though. It's really important though. Oh Lord. So there's no reason to conclude that Yoder was one of these kinds of cases or tailor to specific evidence as the court below reasoned. While the court noted in Yoder that the Amish made a showing that probably few other religious groups or sects could make, because, I mean, the burden on the Amish relating to this would be somewhat unique for the Amish, maybe the Mennonites, but, you know, whatever. The language must be read in the context of specific claims raised by the Amish respondents, the right to withdraw their children from all conventional schooling after a certain age. Contrary to suggestions of the court below, Yoder embodies a robust principle of general application. The Fourth Circuit, who somehow fucked this up, The Fourth Circuit's view that the record in this case is too threadbare to demonstrate a burden on religious exercise is also unconvincing. Guys, I mean, dude, come on. Like, I know it's a preliminary injunction. Okay, I know it's a preliminary injunction and the facts are somewhat sketchy at preliminary injunction stage. This is true. It's not a full merits decision. We haven't had full merits. So the case is somewhat more nebulous than it might ultimately be. But there are a lot of facts. We know the books. We know the policies. We know the teachings to the teachers. We know the fact. Like, there's a lot of information here. I don't know that we can call this threadbare. I think we've got a lot of details, guys. It's fine. We may not know everything, but we know a lot of shit, guys. All right, the court faulted the parents for failing to make specific allegations describing how the books are actually being used in the classrooms. Oh, that was the problem. Yeah, they didn't know. They didn't know how the books were being used in the classroom, specifically on a day-to-day basis. They didn't know what teachers were really actually doing. Why don't you just ask your 5-year-old? I'm sure he'll tell you in detail exactly what happened. Lord have mercy, right? But when deprivation of First Amendment rights is at stake, a plaintiff need not wait for the damage to occur. That too. So as long as, even with standing, like as long as it's imminent injury, you don't have to wait. So you have to have standing, you have to have an injury. But if it's imminent, which, this one definitely is, then, close enough. That's not new law. Yeah. To evaluate plaintiff's claim, the court need only decide whether, if teachers act according to clear and undisputed instructions, a board on religious exercise will occur. It is no answer that parents remain free to place their children in private school or educate them at home. Public education is a public benefit, and the government cannot condition its availability on their willingness to burn their religious exercise. So this is, although I don't know if the court ever used this language, but this is an unconstitutional condition issue. The government cannot, the government cannot create a benefit to you and then obligate that burden on you, forfeiting certain constitutional rights, in particular, freedom of speech and freedom of religion, right? They can't do that. So I don't know why the government would want to do this. But let's suppose that the some state somewhere has a welfare program, as they do, and sometimes people are critical of the welfare program, as they do. And let's say the government said, okay, in order for you to get welfare benefits, in order for you to get our food stamps, you have to sign an agreement. This agreement says you won't publicly say mean things about the welfare or food stamps or office or anything. Now, you can still petition the government privately. So you can still say that this is enough. You can sue us and stuff like that, but you can't go out to the news media and say, I don't like the welfare program. I need more money. Give me more money. Right? So the state creates this program. Yeah, that's not going to work. Right? I mean, it's a benefit. It's a benefit that you're not necessarily entitled to in the first instance. The government doesn't have to, in the first instance, have a food stamp program, right? There's no fundamental right to a food stamp program. But the government can't then condition that benefit on you forfeiting your right to say mean things about us, for example. Can't do that. That's an unconstitutional condition. And so kind of same thing here, right? So you don't necessarily have to take advantage of the public education, at least not anymore. You used to have to. You used to have to take advantage of it because we literally used to make you, and you couldn't opt out of the education at all. But we've decided since then, you can opt out. So this is a benefit. You don't necessarily have to take advantage of it, but they can't condition it on an unconstitutional condition. So that makes sense. Moreover, given that education is compulsory in Maryland, the parents are not being asked to simply forego a public benefit. They have the obligation, enforced by fine or imprisonment, to send their children to a public school unless they can find an adequate substitute. And what if you're poor? And again, so it's that's a problem. Nor is it any comfort to suggest parents can educate their children at home after school. The parents in Barrett and Yoder were similarly capable of teaching religious values at homes, but that made no difference in the First Amendment analysis. It's similarly unconvincing to suggest parents could challenge the educational requirements via a democratic process. The parents have tried and failed to obtain legislative change, and they had every right to resort to judicial process. Yeah, they went to the school board and they did all the things and they lost. And the government tried to shove it down their throat, very literally. But, yeah. Having concluded the board's policy burns the parents' right of freedom of exercise, the court turns to the question whether the burn is constitutionally permitted. Not a chance in this world. Not a chance in this world. All right, fine. All right. In most circumstances, government is generally free to place incidental burdens on religious exercise, so long as it does so pursuant to a neutral policy, citing Smith, Hala Smith. Smith is one of those great foundational cases. So the government doesn't have to provide any special protection for religion writ large, right? If there's a neutral program like Social Security, for example, because some people have religious objections to Social Security, for example. But if there's a neutral program, it's generally applicable, then, that's okay. As long as they treat all religions the same, generally speaking, right? So as long as it's, a general program, it's neutral, and the burden is somewhat incidental, then it's fine. And that's Smith, famous case, Hala Smith. But when a law imposes a burden of the same character as in Yoder, as it does here, strict scrutiny is appropriate regardless of neutral or general applicability. So this might be a bit of new law here. This potentially is a bit of new law, or at least a clarification on these doctrines, right? So Smith said basically this is neutral. And so the board had a non-trivial argument, although to be fair, there were reasons that they lost the trivial argument for other reasons in the case, but we don't need to go into that right now. But at least in principle, how about that? In principle, if perhaps not an application, in principle, the board had an argument that this was Smith, right? It's just a general thing that generally exists. It's neutral. We're not hostile to any religion in particular. We're not doing it for really reasons of religious hatred. We're doing it because we think it's important for transing the youth. Regardless of your religious beliefs. But the Supreme Court draws a line here if it didn't already exist and says, oh yeah, no, if the burden becomes of a character comparable to Yoder, then neutral applicability won't do. So Smith has limits if it didn't already before. So there you go. That's some new law, potentially. To survive strict scrutiny, a government must demonstrate that the policy advances interests of the highest order and is narrowly tailored. Just give up hope. Give up hope if you're the government on a strict scrutiny doctrine. It is not happening. The board asserts its curriculum and no opt-out policy serves compelling interest in maintaining a school environment that's safe and conducive to learning for all students. As a general matter, schools have compelling interest in having an undisrupted school session to conduct learning. Fair enough, right? That much is true. The government has an interest in the function of the government being allowed to function. So your First Amendment right does not, for example, I don't know what your problem is with the DMV, but you have some problem with the DMV. Your First Amendment does not afford you the right to go into the DMV, into the lobby during business hours and creating a ruckus, right? Because the DMV has to be able to function. You can stand outside and have your group, and depending on the size of the group, you might need to get a permit, but you can get your permit and you can have your protest. And even if it's really, really loud, that'll be fine. But you can't go inside and actively disrupt the function of the government. That's too much. So that's the kind of thing they're talking about. And same thing for public schools. Public schools have to be able to public school. So, fair enough. But the board's conduct in continuing its permit opt-outs in a variety of other circumstances, which incidentally, that was also a problem, right? Because you could opt out for other reasons, not just religious reasons. So that hostility to religion thing is looking a little bit more dicey, right? You could opt out for other reasons, or at least in other situations, not just this situation. So yeah, you could argue that there was religious hostility, but let's blow past that for the moment. Without an injunction, the parents will continue to suffer an unconstitutional burden on religious exercise. It is a dissent by Sotomayor. I want points. I want points. I said the dissent would be written by Sotomayor, and it was written by Sotomayor. I want credit. I demand recognition for my Supreme Court talent. I was like, who's going to write this dissent? It's probably Sotomayor. It is Sotomayor. Respect your boy. Respect your boy. Without an injunction, the parents will continue to suffer an unconstitutional burden on religious exercise, and such a burden unconstitutionally constitutes an irreparable injury. An injunction here would both be equitable and in the public interest. Thus, petitioners have shown they're entitled to a preliminary injunction. Specifically, until all appellate review is completed, the board should be ordered to notify the petitioners in advance whether one of the books in question or any similar book is used in any way and allow them to be excused. Alito delivers the opinion of the court in which Roberts, Thomas, Gorsuch, Kavanaugh, and Barrett join. Thomas concurs. Sotomayor, Kagan, and Jackson dissent in a 6-3 opinion because, of course, they do. I would like to take a brief break from Supreme Court discussions to remind ourselves of the books that are in question, because we've been talking about these books for a little while, and some of you guys may not remember or may not have been here in the first place. So I think now would be a really good time to remind ourselves of exactly the books that were in issue. So give me just a second to look that up as you talk amongst yourselves. Because again, they were put on the docket, because of course they were. So I'm just going to go pull them from the docket because I can. All right, let's see. Gotta love public dockets, man, right? Let's see. All right. Where is this thing? All right. Case documents, document search. Okay. Search for this. Great. Invalid text, really? You're killing me. All right. Let's see. That's the right docket. Great. All right. Where is the appendix? Whoa. Okay, this is reverse chronological order. That's why it was confusing for a second. Supreme Court puts it in reverse chronological order. They want to make no, this is chronological. Okay. Application to extend time, petition for writ. Okay, I think it's in the appendix. Okay. It'd be helpful to know which book was written for which students so that I can do this. Because it's going to be in the main document. So give me a second so I can remember which books were written for which or taught to which students. Because it says somewhere in this thing. I know it does somewhere. It's in here somewhere. Give me a second. Continue talking amongst yourselves. If I just search for kindergarten, maybe that will teach me what I want to know. Okay. Well, intersectional allies apparently is another one. Is it the one that was taught though? Let's see. Let's go back to the start. Okay. I think at some point it actually said which books were taught to which grade. That's what I was kind of hoping for. Maybe it's somewhere. All right, well, let's press on for the moment because I don't want to spend too much time, searching. And we'll just go to some of the books and we'll figure out maybe which books were for which grades. Not that it really matters too much, but, to the extent it mattered. Let me just skip to the right part of the appendix with the pictures. Take a look. It's in a book. Reading Rainbow. It's very Reading Rainbow in this case. This is more Reading Rainbow than any case of recent memory. And we're skipping. Still more appendix. A lot of text. Blah, blah, blah. Okay, here we go. All right, let's see. This maybe it says. All right. Okay. A verified complaint. All right. This was mandated for fourth graders. Pride Puppy was mandated for, okay, wait, no. Was Pride Puppy, Pride Puppy was for the 3 and 4 year olds. I'm not sure what 3 and 4 year olds are in kindergarten, but maybe pre-K too. So Pride Puppy was for the 3 and 4 year olds. Love Violet was for the 4th graders. Love Violet was for the 4th graders. Let's see. 5th graders were for Born Ready, the true story of a boy named Penelope. All right. So let's do with Pride Puppy. Let's go with the 3 year olds. Let's do with the book with the 3 year olds. It's in here somewhere. And we're skipping, and we're still skipping, and we're still skipping. More skipping. Okay. Oh yeah, it tells all the ages. All right. So okay. All right. So here apparently were the texts that were approved at various levels, and the actual books are also included. So here are the books that were at various grade levels. Okay, grade level. These were texts by the grade level for which they were approved by the school board. For the pre-K and Head Start, we had Pride Puppy. A young child and their family are having a wonderful time together celebrating Pride Day, meeting up with grandma, making new friends, and eating ice cream. But then something terrible happens. Their dog gets lost in the parade. Lucky there are lots of people around to help reunite the pup with his family. Pride Parade for the 3 year olds. Okay. For kindergarten through 5th grade, we had Uncle Bobby's Wedding. Uncle Bobby's Wedding is about a fun-loving girl named Chloe and her Uncle Bobby, whom she adores. But then she finds out Uncle Bobby is getting married and meets Bobby's intended, Jamie, and worries that Uncle Bobby won't have any time to spend with her anymore. Kindergarten through 5th grade, intersectional allies. We make room for all. In this story, Intersectional Allies, we make room for all. The 9 interconnected characters proudly describe themselves and their background, involving topics that range from physical disability to language brokering, offering an opportunity to take pride in personal story and connect collective justice. Kindergarten through 5th grade, My Rainbow. My Rainbow tells the story of a dedicated mom who puts love in action as she creates the perfect rainbow-colored wig for her transgender daughter, based on the real-life experience of a mother-daughter advocate duo, Trinity and Deshauna Neal. More morning sunlight and love fill the Neal home. Kindergarten through 5th grade, Prince and Knight. Prince and Knight is a children's picture book authored by Daniel Hack and illustrated by Stevie Lewis. Prince and Knight tells the story of a young prince who falls in love with a knight after two work together to battle a dragon threatening the kingdom. After the conclusion of the book, the two wed. It's so on the nose. I mean, they just can't help themselves. It's so hilarious because it's so fucking blatant. I mean, holy shit. I mean, they're not trying to hide the ball. You got to give them that. Damn. Kindergarten through 5th grade, Love, Violet. Valentine's Day brings a shy child named Violet a chance to connect with her crush, Mira, in Sullivan Wilde's uplifting wintry tale. A race through snow, chronographically captured with dance-like grace in Kluwa's simple, life-filled colors, brings the duo together at last, making holiday one of joyful acceptance. Kindergarten through 5th grade, Born Ready, the true story of a boy named Penelope. In this exuberant companion to Jodi Patterson's adult memoir, The Bold World, Patterson shares her son Penelope's frustrations and triumphs on the journey that share himself with the world. Penelope's experience showed children it always makes you stronger when you're true to who you really are. How uplifting. Grade 6. Okay, I guess this book was not appropriate for the kindergartners. We finally found a book that was not appropriate for the kindergartners. That's nice. So 6th grade, Cattywampus. The magical story of a hex that goes haywire and the power of friendship to set things right. In the town of Howler's Hollow, conjuring magic is strictly off limits. Only nothing makes Delphia Gill's skin crawl more than rules. So when she finds her family's secret books of hexes, she's itching to use it to banish her mama's money troubles. She just has to keep it quieter than a church mouse. Not exactly Delphira specially. Trouble is, Catherine Hearn is hankering to get her hands on the school spellbook too. The daughter of a rival witching family. Got to teach the witchcraft, I guess, for some. We are literally teaching witchcraft, but at least we're only teaching it to sixth graders, I guess. The daughter of a rival witching family, Kathy, has reasons of her own to wanting to learn forbidden magic, and she's not going to let an age-old feud or Delphia's contrary way stop her. But their quarrel accidentally unleashes a hex so heinous it resurrects a graveyard full of angry Hearn and McGill ancestors bent on total destruction. If Delpha and Katie want to reverse the spell in time to save everyone in Hollow from rampaging zombies, they need to mend fences and work together. What the fuck? For grade 6, the book The Best at It, Raul Kapoor is heading into 7th grade in a small town in Indiana. The Stardust Middle School is making him feel increasingly anxious, so his favorite person in the whole world, his grandfather, Bai, gives him some well-meaning advice. Find the one thing you're really good at and become the best at it. The 4 little words sear themselves into Raul's brain. While he's not quite sure what he's special at, he's convinced that once he finds it, bullies like Brent Mason will stop torturing him at school, and he won't be worried about staring too long at his classmate, Justin. With his best friend Chelsea by his side, Raul's ready to crush this challenge. But what if he discovers he isn't the best at anything? How exciting. Oh, there's more book. I'm sorry. Grade 7. Ivy Aberson's Letter to the World. When a tornado rips through a town, 12-year-old Ivy Aberson's house is destroyed and her family of 5 is displaced. Ivy feels invincible and ignored in the aftermath of the storm. And what's worth, her notebook filled with secret drawings of girls holding hands has gone missing. Mysteriously, Ivy's drawings begin to reappear in her locker with notes from someone telling her to open up about her identity. Ivy thinks and hopes that the someone might be her classmate, another girl for whom Ivy has begun to develop a crush. Will Ivy follow the strength and courage to follow her true feelings? Ivy Aberden's Letter to the World exquisitely enriches the rare category of female middle grade characters who like girls and children's literature at large. Grade 7, Hurricane Child. Carolyn Murphy is a hurricane child. Being born during a hurricane is unlucky, is it? And 12-year-old Carolyn had her share of bad luck lately. She's hated and bullied by everyone in her small school on the St. Thomas, U.S. Virgin Islands. A spirit only she can see won't stop following her. And worst of all, Carolyn's mother left home one day and never came back. But when a new student named Kalindra arrives, Carolyn's luck begins to turn around. Kalindra, a solemn girl from Barbados with a special smile for everyone. If it's for everyone, how special can it be? Becomes Carolyn's first and only friend, and the person for whom Carolyn has begun to develop a crush. Now Carolyn must find the strength to confront her feelings for Kalindra, brave the spirit stalking her through the island, and face the reasoning her mother abandoned her. Together, Carolyn and Kalindra must set out in a hurricane to find Carolyn's missing mother before Carolyn loses her forever. Grade 8, The Stonewall Riots. Okay. Grade 8, The Stonewall Riots, coming out in the streets. This book is about the Stonewall Riots, a series of spontaneous, often violent demonstrations by members of the gay LGBTQ+ community in reaction to a police raid that took place in the early morning hours of June the 28th, 1969 at the Stonewall Inn in Greenwich Village neighborhood in Manhattan, New York. The riots are attributed as the spark that ignited the LGBTQ movement. The author describes American gay history leading up to the riots themselves, and the aftermath. Includes her interviews of people who witnessed it, including a woman who was 10 at the time. Profusely illustrated, the book includes contemporary photos, newspaper clippings, and other period objects. A timely and necessary read, The Stonewall Riots helps readers understand the history and legacy of the LGBTQ movement. Grade 8, Troublemaker for Justice, the story of Bayard Rustin, the man behind the March on Washington. Bayard Rustin was a major figure in the civil rights movement. He's arrested on a bus 13 years before Rosa Parks and participated in integrated bus rides throughout the South 14 years before the Freedom Riders. He was a mentor to Dr. Martin Luther King Jr., teaching him the philosophies and techniques of Gandhian nonviolent direct action. He organized the March on Washington in 1963, one of the most impactful mobilizations in American history. Despite these contributions, few Americans recognize his name, and he's absent from most history books, in large part because he was gay. This biography traces Rustin's life from his childhood and his first arrest in high school for sitting in the whites-only section of a theater through a lifetime of nonviolent activism. Authors Jacqueline Houtman, Walter Nagel, and Michael G. Long provide middle and high school students with a biography of Rustin that illustrates how the personal is political. Young readers will take away valuable lessons about their civics, history, and 20th century school. This is from the English Language Arts curriculum in the Office of the Curriculum and Instructional Programs for Montgomery County Public Schools. How fun and exciting. Let us read now, my friends. I think we should read the book that was for the kindergartners, or actually the pre-K, right? This is the book for the pre-K. So this is the book they would like to teach the 5-year-olds, 4-year-olds, and 3-year-olds to the extent they're enrolled in pre-K. Okay, let us read now, guys. Let us see whether or not there are any subtle or hidden or discrete LGBTQ messages or signaling. I don't know, guys. I don't know. I mean, I've read the book before, and I just don't know if I can find it. I mean, I don't know what the parents are complaining about. Maybe it's just too subtle for me. I can't find it, but maybe you can help me find it. Maybe you can help me find the subtle LGBTQ messaging for the 3, 4, and 5-year-olds. All right, let's do that. All right, we're going to read the book Pride Puppy now. Here's the cover for Pride Puppy. Features a completely normal parade in every possible way by Robert Stevenson and Julie McLaughlin. Let's read this book for the 3 and 4 and 5-year-olds. Pride Puppy by Robin Stevenson, and I'm going to do this in my best voiceover. Pride Puppy by Robin Stevenson and Julie McLaughlin by Orca Book Publishers. A is for awake, animals and all. B for breakfast and baby and ball. C is for our car, our old Chevrolet. D for our dog, dressed up for the day. E is for everyone under the sun. F for feathers, for flags, and fun. G for grandma at our meeting spots. H for hats and hungry and hot. I for ice cream, sticky and sweet. J for joining crowds on the streets. K for kindness and friends that we're keeping. L for leash and loose and for leaping. M for missing. We search high and low. N for nearly and next time and no. O is for oops. Our hopes are fading. P for puppy, proudly parading. Once again, subtle clues apparently going past my understanding. That I'm not really picking up the LGBTQ theming. It just must be too subtle for me, I guess. There's a lot going on in this picture, guys. There's a lot going on in this. Q for queen in a beautiful dress. R for rainbows and a really big mess. S for school book. S for school bus and students with signs. T for teachers and toddlers in line. There's a lot going on in this image too. U for umbrellas with colors so bright. V for victory and holding on tight. W for wags and whites and wide smiles all around. X for exhausted, asleep on the ground. Y for yawns as we drive away. Z for Z's at the end of the day. And then here's a search and find word list for all the words, I guess, that were featured in the book. Exciting. Thus, that is the end of Pride Puppy, I think. Oh, no, wait. Okay, yeah, this is the back of the book. This is the back cover. It's Pride Day. The whole family's together to celebrate. There's music, dancers, floats, and a lost puppy. Oh, no. An alphabetical seek and find on every page by Orca Book Publishers. Well, that was exciting. So that was one of the books that was involved in the case for the 3-year-olds. Mandatory. You must do it. All the rest. All right, great. All right. Let's see if you had questions thus far, because there probably were. Apparently no. Okay. An honest doubter said, missed my prior super chat question on this, but won't this ruling on universal injunctions make it more difficult to resist future mandates? Yes, it would, by necessity. Yes, it would, because the injunctions can only affect the parties that are involved. So that's, it gives and takes away. So yes. And domesticated phallus of domesticated Vitalis said, can I get a summary of the one you just covered at the time of writing? The geeky one, because I still don't understand. You'll have to ask a more precise question so that I can give you a more precise answer, but I'll do my best. All right, let's carry on with more Supreme Court stuff. And again, if you have questions, please put them in the Q&A box so that I can see them. That's why I started the Q&A box. All right, let's see what's next. Hold on. Okay. All right, where were we? In the docket. All right. Blah, 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 blah. There's an easier way for me to do this. I can just get it straight from the Supreme Court. Why am I making my life more complicated? Why am I making my life harder than it needs to be? All right, let's see. So let's see. Where were we? We did that. We did that. So we did the Trump case, we did the Kennedy case, we did the FCC. Did we do the FCC case? No, we have not. Let's do the FCC case. All right. Cool. Great. We turn our attention to FCC versus Consumer Research from the U.S. Supreme Court. Let's go ahead and do that. The Communications Act of 1934 establishes the Federal Communication Commission and instructed it to make available to all the people of the United States reliable communication at reasonable charge. That objective today is known as universal service. The Universal Service Project arose from concern that pure market mechanisms will leave some population segments, such as poor and those in rural areas, without access to needed communication services. Under the 1934 Act, the FCC pursued universal service primarily through implicit subsidies. using rate regulatory authority to lower costs for some consumers at the expense of others. In 1996, Congress amended the Act and created a new framework for achieving universal service. Section 254 of the amended statute requires every carrier providing interstate communications to contribute to a fund known as the Universal Service Fund. The FCC must use money in the fund to pay for the subsidies. The statute designates the beneficiaries of the subsidies as such as low-income consumers, those in rural areas, schools and libraries, and rural hospitals, and provides detailed guidance regarding communication services to which the beneficiaries should have access. In deciding which services to subsidize, the FCC shall consider the extent to which a service is essential to education, public health, or public safety, and has been subscribed to by a substantial majority of residential consumers. So too, the Commission must evaluate whether a service can be made available at an affordable rate. Section 254 also sets forth principles on which the FCC shall base its policies. Among other things, those principles direct that all consumers, including low-income consumers and those in rural areas, should have access to quality services at affordable prices. The FCC may also add other principles found to be consistent with the Act as necessary and appropriate for protection of the public interest, convenience, and necessity. To calculate how much carriers must contribute to the fund, the FCC has devised a formula known as the contribution factor. The factor is a fraction expressed as a percentage whose numerator is the fund projected quarterly expenses, the subsidy payments it will make plus overhead, and whose denominator is the contributing character's total projected quarterly revenue. So that makes sense, right? So we're going to take all the money that we need and divide it by like all the money you make, and that will provide us a fraction. And that will tell us how much money to give us. Okay. The fraction is a fund expressed as a percentage, as we explained. A carrier must pay into the fund an amount equal to its own projected revenue multiplied by the factor. The FCC has appointed the Universal Service Administrative Company, a private non-for-profit corporation, as the fund's permanent administrator. So we have a private administrator. Okay. The administrator manages the fund's day-to-day operations and also plays a role in producing the financial projections that end up in determining the factor. So this is going to be a non-delegation doctrine case. Each quarter, the administrator, so this is a non-delegation doctrine case. This is you've given governmental authority to a private entity. Okay, yeah, you can't do that. So this is going to be like the first time in, what is it now? A long time. Has it been 100 years? It might be. It's been a long ass moment since the Supreme Court struck down a statute for non-delegation reasons. I think it might be 100 years since they did it. I think it might literally be 100 years since they did it. Or maybe 90. It's been a hot minute. Are we really going to do this for the first time in like 90 years? Because it sounds like we are. All right, the administrator manages the fund's day-to-day operation and also plays a role in producing the financial projections that end up contributing. Each quarter, the administrator projects the fund's expenses, adds up revenue estimates it receives from carriers, and submits those figures to the Commission for approval and eventual use in calculating the contribution factor. In December of 2021, the FCC sent a 25.2% contribution factor for the first quarter. Consumers Research petitioned for review in the Fifth Circuit, contending the Universal Service Contribution Scheme violates non-delegation. Yep. The en banc court grant petition replaced the panel's decision to the contrary. In the full Fifth Circuit's view, the combination of Congress delegation to the FCC and FCC subdelegation to the administrator violated the Constitution, even if neither delegation did so independently. Hell, the Universal Services Contribution Scheme does not violate the non-delegation doctrine, so I guess we're not doing it. Oh well. It's been like 90 years, so I guess we're not doing it today either. Oh well. Article 1 of the Constitution provides that all legislative power herein granted shall be vested to the Congress of the United States. Accompanying that assignment of power to Congress is a bar on further delegation. At the same time, this court has recognized that Congress may seek assistance from coordinated branches and vest discretion in executive agencies to implement the laws it's enacted. To distinguish between permissible and impermissible in this sphere, the court asks whether Congress has set out an intelligible principle to guide what an agency has to do. Under the test, Congress must make both clear the general policy the agency must pursue and the bounds of the delegated doctrine. Although the intelligible principle standard has long guided this court's non-delegation doctrine, Consumer Research insists that a different test applies here. According to Consumer Research, universal service contributions are taxes. Okay, that makes sense. And tax statutes, Consumer Research argues, must satisfy a special non-delegation rule. For those statutes, Congress must set out a definite or objective limit on how much money an agency can collect, a numerical cap, a fixed tax rate, or the equivalent. The relevant law contains no such limit, so in Consumer Research's view, it's unconstitutional. The court rejects the argument. To begin with, precedent forecloses it. In both J.W. Hampton and Skinner versus Mid-America, the court declined requests to create special non-delegation rules for revenue-raising legislation. The test Consumer Research proposes would also throw a host of federal statutes into doubt, as Congress has often empowered agencies to raise revenue without specifying a numeric cap or a tax rate. Consumer Research responds that those other statutes can be distinguished as imposing fees rather than taxes and thus exempted from the numeric limit requirement. But Skinner made clear that whether a charge is a tax or a fee is irrelevant to the non-delegation inquiry. Finally, Consumer Research position produces absurd results divorced from any reasonable understanding of constitutional values. Under its view, a revenue-raising statute containing no numeric qualitative standards can never pass muster, no matter how tight the constraints. But a revenue-raising statute with a numeric limit will always pass limit, even if it effectively leaves the agency with balanced power. In precluding the former and approving the latter, Consumer Research's approach does nothing to vindicate non-delegation or separation of powers. Under the usual intelligible principle test, the Universal Service Contribution Scheme clears the non-delegation bar. Section 254 directs the FCC to collect contributions that are sufficient to support universal service program. The word sufficient sets out both a floor and ceiling. The FCC cannot raise less than what's adequate or necessary to finance the program, but also cannot raise more. And the sufficiency ceiling imposes a meaningful limit on the commission because Section 254 also provides appropriate guidance about the nature and content of the service. The statute makes clear, this part I don't have a problem with. Where the private entity is doing that is more my problem. So like the Congress giving the agency a lot of power is not a problem. The issue with the non-delegation for me would be the private sub-agency, whether that's a problem. But yeah, this part I have no problem with. The statute makes clear whom the program is intended to serve, those enroll in other high-cost areas, with a special nod to rural hospitals. How that's different than other rural consumers is beyond me, but still. Low-income consumers and school and libraries. It also defines those services as the services those beneficiaries should receive. In order for the FCC to subsidize the service must subscribe to a substantial majority view of residential communities identifiable at affordable rates, and essentially together provide the FCC with determined standards. Let me read the super chats that come in as well. A potentially criminal gave $2, say this is a big day of decisions. Yeah, no doubt. Sweden became an uncivilian 2 days from Honest Doubter, said, will this limit the ability to block mandates? Yes. Potentially criminal. Justice Thomas warned about abusing nationwide injunctions. Yeah, he's said it more than once. I'm pretty sure potentially criminal. Yeah. These greedy leftist hogs refuse to listen. Don Lionheart, ACB was a Civ Pro professor. This is a real false. Fair enough. This is Civ Pro taken to the extreme, but fair enough. Stephen Light became an uncivilian. Honest Doubter's been a member for 29 months. Angela Eric Newman sent 50 gift memberships, very generous. And Mike Middleton sent $2.79 to say, just got here, did I miss M for monkeypox? I don't know. Consumer Research, it contends the act gives the FCC balanced authority, but the provision it points to shows nothing of the kind. Hold on. My chat froze again. I think I need to uninstall Firefox and just use Chrome or something. Firefox is giving me problems. All right. Let's see, where were we? Consumer Research contends the act gives the FCC balanced authority, but the provision it points to shows nothing of the kind. It first argues the commission need not actually adhere to each of the criteria section 254 uses to define universal service. Properly understood, however, those criteria are separately mandatory. Next, consumer research highlights section 254's description of universal service as an evolving level of telecommunication service that the commission shall establish periodically in light of advances in technology. That provision, it says, enables the FCC to redefine universal service as it sees fit. But the permission Congress gave the FCC to fund different services over time does not strip the statute of standards and constraint. The commission may still fund only essential, widely used, and affordable services for the benefit of only designated recipients. Finally, consumer research maintains the statutory provision enabling the FCC to articulate additional principles to guide universal policies allows the agency to rewrite its own authority. But that's not so because the relevant section requires the additional principles to be consistent with. Yes, the and other stuff provision. It's the and other stuff provision. So, yeah, just interpret it like the other things in the list. Yeah, no problem. So they cannot change the statute's other principles, much less the conditions on which subsidies go towards and who can receive them. Thank you, K. Schmidt, for 20 gift memberships. Consumer Research separately claims the FCC has improgressively delegated authority to the administrator set contributors. This is a little bit more interesting for me on this legally. In making the argument, Consumer Research invokes what's commonly called the private non-delegation doctrine. In Carter versus Carter, coal, this court struck down a statute authorizing certain coal producers to set rules for the rest of the industry, finding delegation improper because it was made by private persons whose interests are often adverse to the interests of others. But in a counterpart case, Sunshine Coal versus Atkins, an approved a statute permitting private actors to make recommendations to a government agency for approval, disapproval, or modification. That arrangement was valid because the private parties functionally subordinate to the agency and were subject to authority and surveillance. Under this precedent, the commission's use of the administrator here is permissible. The administrator is broadly subordinate to the commission. The commission approves the administrator board of directors, approves its budget, and requires the administrator to act consistent with its rules and directives. And the commission's authority and oversight of the administrator extend to determining the contribution factor. Working within FCC rules, the administrator produces initial projections of cabinet revenues and fund expenses that feed into the factor. The administrator then reports its figures to the commission, which reviews and, if needed, revises the projection. Okay, that's why it's fine. That's why, because they just don't set it and it goes out into the world. That's why, because it still has to be approved by the FCC, governmental agency. So it's the ultimate step is the government, and the fact that they have private contractors helping them is irrelevant because the ultimate action is governmental action. So that makes total sense. So I'm totally on board with that. That's fine. The commission then has 14 days to make additional changes before the factor is deemed to be approved. So although the administrator make recommendations, the commission is ultimately the final authority. Yeah, that does it. The court also rejects the basis of the decision below that the combination of the grant of authority to FCC's reliance on the administrator violates the Constitution, either if neither one does individually. The FCC founded that theory on free enterprise fund versus public company oversight, where this court struck down statute because it gave an executive officer 2 layers of protection from the president's removal authority. Even granting that each layer of protection alone was permissible, the court thought the combination was too much. Accordingly, the Fifth Circuit, by similar reasoning, applied here. Even if Congress lawfully conferred discretion to the commission and the commission lawfully sought assistance, the combination was impermissible. But the court's logic does not work. In free exercise fund, the 2 layers of for-cause protection operate on a single axis, with one exasperating the other. That's not the case here. A law violates traditional non-delegation doctrine when it authorizes an agency to legislate. And the law violates the private non-delegation doctrine when it allows the non-governmental agency to govern. These doctrines do not operate on the same axis. So a measure implicating but not violating one does not come out of measure implicating but not violating another in a way that pushes the combination over the line. Kagan delivers the opinion of the court, in which Robert, Sotomayor, Kagan, Barrett, and Jackson join. Gorsuch, Thomas, and Alito dissent in a 6-3 opinion. Cool. Let's see if there were any questions that came in along the way. T. Flesh said, hypothetically, if one is not given citizenship at birth while the EO is in effect, then later grants citizenship to it eventually being overturned on the merits. Could they run for president? Sure, because the legal conceit would be that they were birthright citizens the entire time. Yes. That redhead said, how does case 1 decision impact people? It impacts people in that when people bring lawsuits against the government, the decision, the injunction only binds the parties. Now, ultimately, when the court decides the issue on the merits, that will be a rule of law that will govern the circuit, assuming it's adopted by the circuit. But the injunction only binds the parties, unless the state itself is a party, then maybe, but those still probably not. So the impact of this is that the government, or for that matter, anyone, can do things to people and can only be enjoined from the parties that are present in the lawsuit. So that's pretty big. That's a big deal. The practical import of that is probably more class actions. But, be that as it may, that's fine. Bora Bora said the question box shows up with the words ask question. Okay. Bora Bora says, is there pending birthright citizenship that will be heard on the merits? Not right now, no. The injunctions or the merits decision is not teed up right now. It possibly next term, because some of these decisions are coming down pretty fast. So possibly there will be a merits decision next term, or relatively soon, but not right now. Can I briefly explain non-delegation doctrine? Sure. Congress can't delegate its authority to pass legislation. Only Congress can pass laws. So it can't give the agency, the executive agency, or anyone else the power to create a law. But agencies can create rules. And so that's the line of delineation. So to keep it simple, let's discuss national parks. I haven't read the statutes on national parks, but I'm going to assume it says something like, national parks should be open to the public, and during such hours as, makes sense. Or I'm going to assume it's open, right? I'm going to assume it says, hey, national parks should be open to the public. And then the National Park Service, for example, has to decide what hours, what parts of the park, and so forth and so on. So the statute says, national parks are for the national people, so they should be open. But during what hours? Under what conditions? How many people? Can they put a cap on how many people come into national park? For reasons, can they do? Yeah, can they? So that's open. So Congress could make more specific choices. Congress could say national parks must be open from 8 a.m. to 8 p.m. They could do that. And that would be well, then the rule's 8 a.m. to 8 p.m. But if it's open, then it's for the agency to decide through the rulemaking process, right? So that's the line of delineation. And at least since I think since 1930, the Supreme Court has never overturned a statute for non-delegation reasons. So the Supreme Court, at least since 1930, has allowed Congress to create as wide rulemaking scope as the agency as they want, because it's Congress's choice. They can make it narrow and they can make it wide, and there is no such thing as wide enough. At least there hasn't been. At least in principle, if Congress gave no guidelines, if Congress created no benchmarks, if Congress created no standards, if Congress created nothing, at least in principle, if they left it open enough, wide enough, it'd be a problem. But it hasn't been a problem since 1930. So hopefully that answers your question. Andy says, are the subs of the SEC held to the same standards as the FCC? Yes. Meaning, are they bound by the same rules? Yes. Is there a famous time non-delegation has been invoked in the past? It hasn't been invoked in 90 years. So they quoted one just now in the case. They cited the case where a coal company was given the power to determine the rates for all coal companies. And when they did, it just became law. It had no review. So that was deemed a problem. So hopefully that answers your question. Kay Schmidt gifted 20 gift memberships. By the way, thank you again for your memberships. They are always appreciated. All right. What else we got today? Ooh, Free Speech Coalition versus Paxton. Last one for the day. That's a spicy one. Where's my soundboard? Hold on. All right. Free Speech Coalition versus Paxton. Yeah. Do I still have that soundboard thing? I guess I didn't. Yeah. This involves porn. All right. So Texas and Florida passed laws, among other things, requiring porn companies such as Pornhub and other companies to get ID, or not necessarily get ID, but verify people's age. And they sued, and that issue has been heard by the Supreme Court. All right, so I know this case fairly well. I read the Fifth Circuit opinion. I thought it made a lot of sense. I thought it would withstand scrutiny in the end. There were parts of it that were problematic for particular parts, but the main thrust of it should be legal, I think, is what I think. So we're going to see if the Supreme Court agrees with me. Here's why. Before we get into this, let's go into why I think this is true. Right? So states have the ability to regulate in the first instance, right? And with respect to adult entertainment, of course, their ability to regulate by, for example, requiring the strip club to check ID. Yeah. So the government can determine, within some bounds, not infinitely, but they can determine like where adult businesses can be located. They can say like what the rules are for getting in. You have to present ID. Maybe that could be a rule. Like they can do that, or the adult bookstore or the adult, they have to check ID every single time. They must, right? They must do it every single time, regardless of age, right? So that's sort of the baseline principle. Like the baseline principle is states have the ability to regulate. They have the ability to pass laws, and particularly as it relates to adult businesses, their power is more expansive than it would be for other companies. Now, this rule by Texas and Florida implicates dormant commerce clause, right? Because you have the thing with a strip club or the thing with an adult bookstore is it's a physical location that exists physically somewhere. You have to actually go there, and it's located, in a state as it would be because it's on a piece of property. Internet porn providers such as Pornhub, of course, don't have physical locations in this sense. They can be accessed from everywhere. And so there is a potential problem. First of all, there's a free speech issue, but it doesn't work. So the porn companies are like freedom of speech, but it doesn't work because of all the cases I just mentioned. Their next argument would be dormant commerce clause, that this is too unduly burdensome. So the problem is states cannot impose rules that would unduly burden interstate traffic, right? They can't pose rules that unduly burden interstate traffic. And Pornhub and other companies' complaint is that, well, every state could pass different rules, and then, we could potentially have 50 of them, and we have to comply with each of them, and that'd be a real pain in the ass. And it might present some technical problems as well. I don't think dormant commerce clause analysis works for the companies. First of all, as I sort of mentioned already, this is in a traditional domain of regulation, particularly as it relates to adult content. So I think that gets you a long way. And I don't think that the thing is so burdensome that it because it doesn't seem to require the company to upend its architecture in a way that would present a problem. So I don't think it's unduly burdensome in this sense. So my view is, and the Fifth Circuit, and so Florida passed a law and Texas passed a law. They disagreed as to parts. But my view is that I think the regulation I think the statute is broadly legal. At its core, it's legal. There might be aspects of it that are problematic, but at its core, it's legal. That's what I think based on the case law. So we're going to see if I got this one right, because this is a case I've been following very closely. It's a case I followed at the district level. It's a case I read all the courts of appeal decisions, a case I read the briefing. So I would really like to have gotten this one right. So let's see if I got it right. All right. Let's see how good my Supreme Court foo is today. All right. We turn our attention to Free Speech Coalition versus Paxton in his capacity as the Attorney General of the United States. I apologize, Attorney General of Texas. Texas, like many states, prohibits distributing sexually explicit content to children. In 2023, Texas passed a law requiring certain commercial websites, and they defined it, by the way, like to only be, I forget how they defined it. It doesn't really matter, but they defined like what websites were in a way that seemed to be fine. So like, you know, you're not going to get a void for vagueness kind of thing. It seemed to be sufficiently defined. So no problem there. Okay. Texas enacted a law requiring certain commercial websites publishing sexually explicit content that's obscene to minors to verify visitors that are 18 or older. Knowing violations subject covered entities to injunctions and civil penalties. And incidentally, by the way, the obscenity law for under 18 is different than adults. So that is a valve. That's, you know, what is obscene for children and what's obscene for adults is not legally the same. Petitioners, representatives of the pornography industry. It was a pornography store. I was going to a pornography store. Petitioners, representatives of the pornography industry, sued the Texas Attorney General to enjoin enforcement as facially unconstitutional under the First Amendment freedom of speech clause. I think that's a loser argument. I don't think the First Amendment goes anywhere. I think that's a loser. They allege that adults have right to access the covered speech and the statute impermissibly hinders them. Yeah, get fucked. The Fifth Circuit held that the injunction was not warranted because petitioners are unlikely to succeed in the First Amendment claim. The court viewed the law as a regulation of distribution to minors of materials obscene for minors. It therefore determined the law is not subject to any scrutiny under the First Amendment. Held, the relevant law triggers but survives intermediate scrutiny because it only incidentally burns protected speech of adults. So, uncivil was right. Huzzah for uncivil. Huzzah for uncivil. My prediction was correct. Right? It's like, yeah, broadly, this is going to be fine. And it is. Yeah. So, yeah, I mean, yeah, I was right. I want credit. I want more credit. I need the credit. I want your love and I want your admiration. I want your love and admiration. And we're not continuing until the chat gives me love and props. I demand the props to which I am due. I am entitled to my props and I demand payment of my props. Thank you. Not seeing enough props in chat yet. I'm still waiting. Huzzah. Keep it coming. Keep it coming. You get paid in pasty buns. Nice. All right, we can continue now. To determine whether a law that regulates speech violates the First Amendment, this court considers both the nature of the burden imposed by the law and the nature of the speech. Thank you, Tony, for the $5. That's appreciated. Laws that target protected speech based on communicative content are presumptively unconstitutional and may be justified only if they satisfy strict scrutiny. Laws that only incidentally burden protected speech are subject to intermediate scrutiny. So, fair enough, right? We're not trying to regulate the content, right? We're just trying to like determine who can get access to it, and that's not the same thing. So, yeah, so it's more of an incidental thing. I'm cool with that. $20 from Printer God, props, thank you. Laws that restrict only unprotected speech such as obscenity receive rational basis review. History, tradition, and precedent establish that sexual content that is obscene to minors but not to adults is protected in part and unprotected in part. States may protect minors from accessing such content, but may not prevent adults from doing the same. So as I said, like obscenity doctrine is different for minors versus non-minors. So, yeah. The relevant law, therefore, only has an incidental effect on protected speech and therefore subject to intermediate scrutiny. The First Amendment leaves undisturbed states' traditional power to prevent minors from accessing speech that's obscene from the minor's perspective. That power includes the power to require proof of age before the individual can access the speech. It follows that no person, adult or child, has a First Amendment right to access such speech without submitting age. Right. If we're going to bar minors, then we're going to have to be able to verify their age, which includes adults. So, sorry, adults, that you have to, present ID or whatever, but deal. One free lap dance coupon, excellent. The power to verify age is part of the power to prevent children from accessing speech that's obscene. When the Constitution reserves a power to states, that power includes ordinary and appropriate means of exercising it. Requiring proof of age is ordinary and appropriate means of enforcing age. It'll be interesting to see what Pornhub does now. For those of you who don't know, because I'm sure no one in this chat has ever visited Pornhub ever before. But, not that I would know this, of course, from, I only know this because it was mentioned in the briefing. This is the only reason I know this information, because it was mentioned in the lawsuit in the briefing in some place. But Pornhub has for some time been having a statement about how they, they're not happy with the Texas law and blah, 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 blah. So it'll be interesting to see to what degree, if at all, they change their statement in lieu of this. They can continue expressing their displeasure. It should be interesting to see if they change it. Not that I would know, because I'm not checking it, of course, personally, but maybe someone will bring it to my attention some other way. All right. All right. Requiring proof of age is ordinary and appropriate means of enforcing age-based limits. Age verification is common where a law draws age-based limits, for example, obtaining alcohol, firearms, or a driver's license. Obscenity is no obsession. Most states require age verification for in-person purchases of sexual material, and petitioners concede the in-person requirement of this kind is traditional and almost surely constitutional. As a practical matter, age verification is necessary to effect a prohibition on minors accessing age-inappropriate sexual content, especially on the internet. Because the relevant law simply requires proof of age to access content that's obscene, it does not directly regulate adults' protected speech. Adults have the right to access protected speech available only to minors, and submitting to age verification burns the exercise of that right. But adults have no First Amendment rights to avoid the age verification itself. Any burden on adults is therefore incidental to regulating the activity not protected by the First Amendment. This makes intermediate scrutiny the appropriate standard. Applying the more demanding standard of strict scrutiny, is there dissent in this case? And if so, is it from the liberals? And if so, why? We're going to be here for a while, guys. I don't think this stream is going to end because we're going to have to read some dissents, or at least skim some dissents. Or ask ChatGPT to summarize the dissents or something, because we're going to have to figure out what the hell. We're going to have to figure out what the hell is going on with some of these dissents, I swear to God. Who wrote the dissent in this case? Jackson? Feels like a Justice Jackson dissent. Although petitioners insist that traditional in-person requirements would survive strict scrutiny, the court cannot share their confidence. Strict scrutiny is designed to enforce First Amendment prohibition on content-based laws, and it succeeds in that purpose only if, as a practical matter, it's almost always fatal in fact. Strict scrutiny is not the appropriate standard for laws that are traditionally and widely accepted as legitimate. Precedent does not call for the application of strict scrutiny. The court's decision applying strict scrutiny in this context all involve law that banned both minors and adults from accessing speech that was at most obscene to minors. The court has never before considered whether a more modest burden of age verification requires trigger strict scrutiny. Texas contends that only rational basis review applies. This position fails to account for the incidental burden that age verification necessarily has on adults' First Amendment rights to access speech obscene only to minors. Although differential, intermediate scrutiny plays an important role in ensuring legislatures do not use obscenity's legitimate purpose to disguise efforts to suppress fundamental rights. The relevant law survives intermediate scrutiny because it advances important governmental objectives unrelated to suppression of free speech and does not burn substantially more speech than necessary to further those interests. The relevant law furthers Texas' important interest in shielding children from sexual contact and is adequately tailored to that interest. States have long used age verification requirements to reconcile their interest in protecting children from sexual material with adults' rights to avail themselves of such material. The relevant law simply adapts this traditional approach to the digital age. The specific verification methods the relevant law permits, government-issued identification and transactional data, are also plainly legitimate. Both are established methods of verifying age already in use by many pornographic websites and other industries with age-related services. Petitioners' counter-arguments are unpersuasive. Petitioners object that other means of protecting children are more effective and that children are likely to encounter sexually explicit content on other websites subject to the requirements. Kagan filed the dissent. Damn, got that one wrong. It was Kagan, not Jackson. Damn. But intermediate scrutiny does not require states to adopt the least restrictive means of pursuing their interests or evolve all under inclusiveness. Thomas delivers the opinion of the court. Kagan dissents along with Sotomayor and Jackson. All right, so that is the end of the decisions today. What a lot of exciting decisions. Yeah, what a lot of exciting decisions today, man. That was 1, 2, 3, 4, 5 decisions today, and some big ones today too, man. We can camp out here for a while, guys, on reading some of this stuff in detail. If you guys are interested, it would be helpful if, there were some super chats and stuff to encourage me. I just, because it's a lot of stuff. Wasn't the hub sued for not verifying ID? Yeah, that's what this is. That's what this is. Where they sued or whatever. In any event, that's what this is. So, yeah, the hub will be sad. The hub will have to put up a black banner of sadness, I guess, or something. All right, let me get some water. All right, I need to do a couple things for my own sanity. First, I need to get some water. Second of all, I need to order new food supplies. Third, I need to check on my watch status and all that stuff. But we'll leave Chair in the background, and you can spend time with Chair. The Louisiana redistricting case, they did re-argument. Interesting. Yeah, give those sweet dissenting opinions. I know. Yeah. Ah, Lord. I wonder if there are any other lawyers from LawTube who want to discuss this that are awake and interested. I could use some other stuff. Oh, I have water in front of me. I still need to order food, though. You sent me 2 things? All right, let's check this out. Tim Walz is being sued for something. For encouragement, thanks for $10. Yeah. Do we need to verify to spend time with the chair? Good question. All right, I need to order food. I already had the food in my cart. I just haven't actually pressed the order button, so now would be a good time. Let me just make sure that I have everything I need. I could use some more Crystal Light. What flavor do I want? I just want my peach tea that I always get. I like it. Why get anything different? Pick up? Oh, delivery. Okay, that's what I want. Multi-pack, 10 packets. Okay, I need get 2 of those. All right, let's see what else do I need. I'm making chicken and rice again. So I'm going to get 3 blocks of Philadelphia cream cheese. I'm going to get myself a bag of 20 ounces of pepper and onion blend. I'm going to get myself 4 pounds of chicken, and then some crushed red pepper, and also some chicken broth, and also 1 small can of sun-dried tomato. I'm not sure how much that will help, but I'm going to add that in for a little bit of extra flavor. So that's what I'm kind of thinking, along with jasmine rice. If anyone has any thoughts on that. Yeah, I'm just getting it from Walmart. Because why not? And I'll also get myself some more unsweetened almond milk and another thing of oatmeals because I'm running out. And yeah. Rotel. That's actually an interesting idea. Okay. Let's see if I can get some Rotel. Okay. You get myself just 10 ounces of Rotel. Or maybe 2 things of Rotel. I get myself 2 things of Rotel. You had me until jasmine rice. What's wrong with jasmine rice? I like jasmine rice. Okay. Can I get this? All right, cool. Get 2 things of that. Great. Yeek. All right. All right. So we now have 3 things of Philadelphia cream cheese, 20 ounces of pepper onion blend, 4 pounds of diced chicken breast, jasmine rice. We've got 2 cans of Rotel with green chilies. We got some red pepper flakes. And we got some chicken broth. That sounds pretty good, right? All those things sound good. Do an unboxing. All right, today I'd like delivery today. 3 o'clock. Yeah, 3 o'clock is fine. I should have ordered earlier so I had the food so I could have been cooking this whole time. I can get express delivery for $10, but like, do I need to make it right now? Tempted. Yeah. I have minced garlic, so I already have that. All right. Okay. All right. Now, what is the status of my watch? How's that doing today? They're now estimating delivery between June 30th. They're saying I'm not going to get my watch for 3 days. This displeases me. I don't get my watch till the 30th. This displeases me. That's Monday, man. All right, let's read some dissents. Let's see. Well, let's turn our attention to the universal injunction case. Let's read some of the dissents in this for a while. We could ask ChatGPT to summarize it. Actually, that's not the worst idea. Let's ask ChatGPT to summarize it, and then we can go from there if we want to do more than that. But I like this plan because it might make my life a little bit easier. Let's ask ChatGPT. All right. All right. What are we talking about? We're talking about Supreme Court stuff today, Team Brittany. The most exciting stuff in the world. At the moment, we're talking about universal injunctions and how they might relate to birthright citizenship. Grubhub has free delivery through Prime. I forgot about that. Could have gotten through Grubhub. Fair point. Fair point. Because I have Prime. Yeah, that's a good point. All right. Justice Sotomayor's dissent raises profound objections to the majority's decision to curtail so-called universal injunctions. Arguing it undermines both longstanding equitable practices and poses an existential threat to the rule of law. Sotomayor begins by emphasizing that every court to consider the president's executive order is found to be patently unconstitutional. Well, on the injunctive standard, yes, but they haven't really gone to the merits yet. And enjoined its enforcement universally, precisely to shield all U.S.-born children from being stripped of their citizenship. By limited relief only to formal plants, the majority allows government to apply the order to anyone else, thereby risking deprivation of citizenship and tenant benefits for countless newborns whose families have not yet been sued. Risk of a two-tiered citizenship regime. She warns that a narrowing injunction named parties would create a chaotic two-tiered system where some children are recognized as citizens and others not, depending on their birth circumstances, but depending on whether parents were swift or well enough connected to file suit. The result would imperil children's access to Medicare, SNAP, Social Security, and even lead to U.S. deportations. Equitable and complete relief. Sotomayor rebuts the majority's cramped view of equitable authority, showing that the district courts carefully found narrow injunctions impractical and insufficient to provide complete relief. In particular, she notes this Fourth Circuit's conclusion that injunction limited to the organizational plans representing hundreds of thousands of new members would be unworkable. By the way, Team Brittany, I just want to say I appreciate you being here, recently and spending time. Appreciate you, your value add to the channel. So I appreciate you being here. We appreciate all our mods. Our mods are great. They help me. Rule of law. Central to dissent is the principle judiciary must be able to order the executive to obey the law. By forbidding universal injunction, the majority creates a zone of lawlessness, which the executive can persist in enforcing unconstitutional policies against non-parties. She sees this as a direct affront to the Constitution designed to bind even the president to command an immortal wound to the rule of law. Wow. Finally, Sotomayor undermines the class action mechanism or imperfect and often slow alternative burdened by certification hurdles. Yes, interlocutory appeals and procedural delays that cannot match the urgency. That's funny. All right, let's that's an interesting summary. But I want to at least skim some of the language itself. I just wanted to get a flavor of it to make my life a little easier. Thanks for a $10 super chat. Thanks, Kurt, doing the hard shift today. Yeah, no problem. I'm here. For some reason, some people just don't think this is yes, it's very interesting to me. It's very interesting to me that, Karen Read gets so many people watching her, but the Supreme Court doesn't when it's more important. It's like, it's more important, impacts a lot more people. It's like, I find the whole thing very fascinating. I don't know. What can you do, man? What can you do? They don't show it? Yeah, well, I wonder if I could get deep fake it or something. It probably could. Because it shouldn't be that hard to deep fake it. There's audio too, so that would help a lot. And then deep fake the animation or deep fake the proceeding. Probably could do it with enough effort. I don't know if that would help, but you could do it. Yeah, nobody but me seems to be talking about it. Yeah, I know. Which is also interesting, right? It's interesting, I guess. Like, how can other lawyers not think that this is the greatest thing ever? I don't know. For me, it's the greatest stuff ever. But some lawyers are definitely more trial lawyers than me. That's for sure, right? That's like, I'd rather live here than in a trial. You know, so. Sue the Supreme Court to allow cameras. I don't think that's going to work. If wishing made it so, though, right? All right, let's read some of this dissent. This should be interesting. Children born in the United States and subject to its laws are United States citizens. That has been the legal rule since the founding and was the English rule well before then. This court once attempted to repudiate it, holding in Dred Scott. Wow, I mean, we're not shy, are we? That children of enslaved Black Americans are not citizens. To remedy that grievous error, the states passed in 1866 and Congress ratified in 1868 the 14th Amendment Citizenship Clause, which enshrined birthright citizenship in the Constitution. There has remained accepted and respected by Congress, by the executive, and by this court until now. Spicy. It is now the president who attempts in executive order to repudiate birthright citizenship. Every court to evaluate the order has deemed it patently unconstitutional and for that reason has enjoined the federal government from enforcing it. Undeterred, the government now asks this court to grant emergency relief, insisting it will suffer irreparable harm unless it can deprive at least some children born in the United States of citizenship. The government does not ask for complete stays of the injunction as it ordinarily does before the court. Why? The answer is obvious. To get such relief, the government would have to show the order is likely constitutional, an impossible task in light of the text, history, and precedent. So the government instead tries its hand at a different game. It asks this court to hold that no matter how illegal a law or policy is, courts can never simply tell the executive to stop enforcing it against anyone. Instead, the government says it should be able to apply the citizenship order, whose legality it does not defend, at least for the moment, to everyone except the plaintiffs who filed the lawsuit. Scotch bottle? What are you talking about? Are you talking about me? Are you talking about me drinking? Because if so, I don't appreciate that. I don't drink really anymore. I basically don't drink anymore. Except like, you know, when I'm out or something. Like I that's not nice. Let's see. No right is safe in the new legal regime the court creates. Today, the threat is birthright citizenship. Tomorrow, a different administration may try to seize firearms for law-abiding citizens or prevent people from certain faiths from gathering to worship. That's true, right? It does swing both ways. That's absolutely true. The majority holds absent a cumbersome class act litigation, court cannot completely enjoin even such plainly unlawful policies, unless doing so is natural to afford the formal parties complete relief. That holding renders constitutional guarantees meaningful name only to individuals who are not parties. Well, on the injunction, it does. Again, that's true. But when they get to the merits and they make a merits decision, that's going to be a legal decision, particularly if it's applied by the Court of Appeals. Yeah. Because I will not be complicit in so grave an attack on our system, I dissent. The majority entirely ignores whether the order is constitutional because that's not the issue. Then she's going to talk about the merits for the while. So she's going to talk about the merits of the issue, which is not before the court, which is slightly annoying. Thank you, Cool Springs, for the donation on coffee. I do appreciate it. It's very kind of you. Yeah. Let's see. Throughout the law, legislation didn't always limit its promise. Infamously, the court departed from birthright citizenship with Dred Scott, holding that slave children are not included, tend to be included on the word citizenship. Section 1 of the Civil Rights Act clarified this. The lawmakers ratified the 14th Amendment, understood to extend citizenship to all children born here regardless of parental citizenship. That's not necessarily clear from the history, incidentally. Indeed, some objected to passage on this ground, complaining it would permanently extend citizenship to immigrants who invade state borders as settled as trespassers. Proponents agreed, if not with the anti-immigration sentiment, the clause would extend citizenship to children of immigrants. For example, Senator Collins of California confirmed to the floor that children born here of Mongolian parents shall be declared by the Constitution to be entitled to civil rights. Yeah, but are they here legally? We've declared that by law and now propose to incorporate the same. Not one senator disagreed. Well, that's not necessarily true. That doesn't seem to be true from the understanding. In the end, the citizenship clause was no legal invocation. Following the ratification, they're going to talk more about the merits, still more about the merits, still more merits. She does understand the merits are not at issue, right? But she wants to write about them anyway. She might be right on the merits. It's just not the issue today. There seems to be language that goes the other way, but she might be right on the merits, but it's just not the issue for the moment. So like, I just can't be bothered to care. State citizenship order, blah, blah, blah. Judicial court for determine only national order for March 13 of order, partially granting remarkable request, stores a well-ordered principle. Government's false shelter, Sarah's birth, suffer irreparable harm. Government's not even correct on the merits of universal injunctions. The contrary, universal injunctions are consistent with long-established principles of equity. What's more, the cases do not even squarely present the legal question. That's because even if the majority were right, the injunctions can all fall completely related to plaintiffs. Each of the lower courts here correctly determined the nationwide relief they issue was necessary. So even ignoring the traditional framework, its bedrock principle, blah, 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 blah. Blah, 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 blah. Yeah, I mean, this case is not about the issue at hand. Sotomayor does understand that, right? This case is about universal injunctions as a class of things, right? Because this affects all universal injunctions. That's the point. Who dissents? I believe it was Sotomayor. Yeah. Unsurprisingly. The majority of this court nonetheless rushes to address the merits of the application, holding that universal injunctions exceed the authority. Majority has remained pledged to its fealty, history, and tradition. The eliminates an equitable power firmly granted centuries of equitable practice. Runs directly counterpoint, blah, 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 blah. And then they talk about the Bill of Peace, which we discussed earlier. Equitable authority. I did a workout yesterday, by the way. It was good. I felt good. I enjoyed it. I want to go again. I want to go to the gym again. I want to feel good again. I want to feel buff like Alessi. Alessi's showing me up in so many different ways. Make good reasons not to issue universal injunctions when the merits are open to reasonable disagreement. Majority contrary reading falls flat. Blah, blah, blah. Stumbles out of the gate. Extinguish appeals of peace. Blah, blah, blah. Did I drink my 33 ounces of water? No, but I really wish I had. I had some water laying rest from yesterday. This is my water bottle I have. It's 1.5 liters, so I have a bigger water bottle than Alessi I get, but I didn't drink it. I need my hormones checked. No problem. I've already done that. Yeah, I've already done that. I'm already on TRT. Speaking of which, it's Thursday and I need to take the medication to counteract the estrogen because it's Thursday. So I need to do that. So give me a second to do that real fast because I need to do that every Thursday. What day is it? Is it Friday? Yesterday. What day of the week is it? I didn't do it yesterday. I'll do it today. Friday? Or what days of the week it is half the time? Friday? Okay, that also means I need my TRT injection today. So I also need to do that. Let me go ahead and do that so I don't forget. BRB. All right, healthy Kurt is better, Kurt. All right, we're back. We're back. Yeah, and Astrozoli. Well, yes, exactly. That's what I. Yeah, exactly. That's what I take. Yeah. So yeah. Okay. Yeah. All right. Great. Let's see. All right. Let's see. Where were we? The bill piece bears some resemblance to monetary procedures, not mean they can also use historic look. Okay. Blah blah blah. Supplement my authority. Da, 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 da. He has majority view of the law cannot justify emergency relief. The court recognized some cases require broad remedy. Majority does not resort to hypotheticals. Blah 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 blah. Okay. Okay. All right. Cool. Let's see what. That's ChatGPT about the majority opinion. That's ChatGPT. What it says about that issue. Come on, ChatGPT. Think faster. Yeah, rather than definitively endorse or prohibit universal injunctions, state the majority declines to take up the argument and remands the lower court to determine whether a narrow injunction is appropriate. For example, limiting enforcement only within each respondent state or directing agencies to treat covered children as eligible for benefits. So yeah, they kind of just like they leave it open for another day. That's kind of what I thought from the majority opinion. Yep, that makes sense. Cool. What do you guys want to talk about? Do you guys want to do another dissent or do you want to do something different? You guys want to play games or something for a while or? I don't know. Let's see. Mahmood versus Taylor. Let's read this one. Let's watch that. Let's watch the. This is good. Let's watch the. Let's read the minority opinion with the gay books, because that was a lot. Laurie Daybell filed for a new trial. Sure, why not? Let's read the dissent in the gay books because this is probably going to be mildly hilarious. Preamble really that long? I guess it was. Thank you. I'm glad to be here too. Read the file cabinet ruling. Yeah, see what that case was about. Yeah, maybe. Meme Copium was giving me a crazy shout out the other day. That's very nice. I appreciate that. That's very kind of him. It's always nice to be liked and respected and admired. It's always, those are good things. Here's one of the books. Yeah, one of the books that we from the case. After Pi, Uncle Bobby and Jamie made an announcement. We're getting married, said Uncle Bobby. This is one of the books for the K through 5. Mommy whooped and hugged him. Daddy shook hands with Jamie. Everyone was smiling and laughing and crying and laughing. Oh Lord. Everyone except Chloe. They actually put I find this hilarious. They put the images from the book in their opinion. That's just mildly hilarious to me. It's not in an appendix. It's actually in the text of the opinion. They put the gay book in the opinion. That's mildly hilarious. Oh yeah, book notes. This is what I'm not sure which book this is, but yeah, book notes for one of the books. Sex and gender are related, but not the same. And then it talks about what a hijab is for a while. That's a lot. Here's from the two princes getting married, or the prince marrying the knight. And on the two men's wedding day, the air filled with cheer and laughter, for the prince and his shining knight would live heavily after ever. Uh-huh. Yeah. Gay books in school is another example of a slippery slope fallacy, not in fact being a fallacy. Yeah, you're right. Like, they would never do this to kids. Yeah, exactly. Not only were they doing it, they were mandating it. Like, damn, they went all out. I'm really looking forward to Witcher 4 coming out. That should be pretty awesome. I'm hyped. I am very hyped. I love the fact they put the text from this in the opinion. This is the copies of in the opinion. This is great. There's a lawyer who lives in Asia. That would be Legal Mindset. I haven't seen anything from him in months. He's around. He definitely has channel. He's pretty big. He's bigger than me, I believe. I think he has his base. We get along reasonably well. I'm on reasonably positive terms with everyone in LawTube, with the notable exception of, yeah. So I'm on reasonably good terms with everybody, I think. Yeah, I don't know how they're going to deal with the lore issue, and I'm not 100% sure I necessarily care. Yeah, I'm not exactly sure how they plan on dealing with the lore issue with Cersei being a Witcher, assuming she's a full Witcher, assuming that's what's going on. I'm not sure how they plan to deal with the lore issue. I'm also not 100% sure I care. We'll see how it goes, though. Justice Sotomayor. All right, let's read this dissent. This is going to be interesting. All right, why is it okay that we mandate transing the kids? This should be interesting. This should be good. All right, Justice Sotomayor, sell me. Public schools, this court has said, are at once the symbol of our democracy and the most pervasive means for protecting our common destiny. They offer children of all faiths and backgrounds an education and opportunity to practice living in our multicultural society. That experience is critical to our nation's civic vitality. Yet become a mere memory. Wow, man, calm down. Yet become a mere memory if children must be enslaved from exposure to ideas and concepts that may conflict with their parents' religious beliefs. Today's ruling ushers in a new reality, casting aside long-standing precedent. This court invites a constitutional right to avoid exposure to subtle themes. Subtle. Okay, chat, you saw the books. Did you think the themes were subtle? Did you think the themes were subtle? Subtle themes that are contrary to religious principle parents wish to instill in their children. Exposing students to the message that LGBTQ people exist and their loved ones may celebrate their marriage and life events, the majority says, is enough to trigger the most demanding form of judicial scrutiny. That novel rule is squarely foreclosed by a precedent offers no limiting principle. Given the great diversity of religious beliefs in our country, countless interactions that occur every day in public school might expose children to messages that conflict with a parent's religious beliefs. If that is sufficient to trigger strict scrutiny, then little is not. The result will be chaos for this nation's public schools, requiring schools to provide advance notice and a chance to opt out of every lesson plan or story time that might implicate a parent's religious beliefs will be impossible and administrative burden. The harm will not be borne by educators alone. Children too will suffer. Holy shit, man. This is a lot. Damn. Classroom disruptions and absences may well inflict long-lasting harm on students' learning and development. Worse yet, the majority closes its eyes to the inevitable chilling effect of its ruling. Many school districts, and particularly those in the most resource-strapped, cannot afford to engage in costly litigation over opt-out rights or divert resources to tracking and managing student absences. Schools may instead censor the curricula, stripping material that risks generating religious objections. The court's ruling, in effect, thus hands a subset of parents the right to veto curricular choices long left to local elected school boards. Because I cannot countenance the court's contortions of our precedent and the unavoidable harms that will follow, I dissent. Holy shit. This is a lot, man. How you doing, Travis, today? How's it going, Travis? By the majority's telling, the Montgomery County Public School Board has undertaken an intentional campaign to impose upon children a set of values and beliefs that are hostile to their principles. Yeah, kind of, sort of. The court draws on excerpts from board documents and statements shorn of context that it claims reflects the intent. The full record reveals a starkly different reality. In years leading up to the present dispute, the board determined that the boards in its English language curriculum failed to represent many students and families in the country or the county. The board has long been committed to protecting or promoting a fully inclusive environment for all students by using instructive materials that reflect the diversity of global community, including persons with disabilities, persons from diverse racial, ethnic, and cultural backgrounds, as well as persons of diverse gender identity, gender expression, or sexual orientation. Yet certain perspectives, the board concludes, were absent from its English language curriculum. Again, aren't we supposed to be just teaching English in the English language curriculum? But whatever. The board, for instance, was determined that some races of culture were not accurately reflected. In response, it added books like The Leavers, which tells the story of an Asian American immigrant family, and the March Trilogy, which recounts the life of civil rights leader John Lewis. The board found that LGBTQ children and families were similarly unrepresented in its English language curriculum. The book taught in English classes simply did not include LGBTQ characters. To fill in the gap, the board worked with a community of specialists to identify the LGBTQ inclusive books it could incorporate into the existing curriculum. After a years-long process, the board announced on October 22 that it would add several new books in the elementary school English language curriculum, 5 of which are at issue in this case. Uncle Bobby's Wedding tells the story of a young girl named Chloe and her favorite uncle. Chloe loves spending time with her Uncle Bobby, and the two often go on adventures like boating trips and stargazing outings. One day, during a family picnic, Uncle Bobby announces he's engaged to his friend, Jamie. The announcement is met with much excitement, and the whole family is smiling and talking and crying and laughing. Chloe, however, is apprehensive. She tells her uncle she doesn't think he should get married because she wants them to keep having fun together like always. Uncle Bobby promises they will still have fun together, and he and Jamie take Chloe out on trips to the ballet, the beach, and out camping. Chloe's excitement for the wedding grows, and on the day of the ceremony, she was so happy she felt like doing cartwheels on the aisle. The story ends with everyone dancing happily at the wedding under the light of the moon. Low. Yeah, you're getting PTSD from seeing the name Chloe. I know, right? Because the majority selectively excerpts the book in order to rewrite the story, readers are encouraged to go directly to the source, reproduce below. We've read it. We've read the book, but it's nice that you're going to reproduce the whole book too. Lord have mercy. The remaining books play on similar themes. Prince and Knight tells the story of a prince who falls in love with a young knight after the knight helps him defeat a fearsome dragon. Love, Violet, tells the story, describes a shy girl who has a crush on her classmate Mira, and eventually gives her Valentine's Day card that says, "For Mira, love Violet." Other books introduce readers to children from different backgrounds and identities. Intersection Allies features 8 different characters, each of which have their own unique attributes. Alexandra, for instance, uses a wheelchair that allows her to zip, glide, and play, while Kate prefers superhero capes over skirts and frills as pictured in a gender-neutral bathroom. Born Ready, the true story of a boy named Penelope, I like how when she describes it, like she's describing this, and it just makes me like want to rule against her even more. It's like, you have successfully identified the problem. It's like, you're not selling me on anything except, decide against you harder. That's the only thing you're selling me on right now. Decide against you harder. Born Ready, the true story of a boy named Penelope, tells the story of a child who likes skateboarding, baggy blue jeans, button front shirts, math science, and getting straight A's, and most of all, wants a mohawk haircut. When Penelope tells his mother that he's a boy, she accepts him. "However you feel is fine, baby," she says. When Penelope's brother expresses skepticism, mother says, "Not everything needs to make sense. This is about love." Yeah. The 5 storybooks introduce readers to LGBTQ characters, but they draw on many themes common to children's books. Indeed, Montgomery County Public Schools libraries are replete with children's books that tell similar stories about overcoming differences, fairy tale romances, and celebrating big milestones like weddings. The board directed the schools to use the new books in the same manner as all other books in the English language program, namely to assist students with mastering reading concepts like answering questions about characters, retelling key events about characters in a story, and drawing inferences about story characters based on actions. The board made clear to individual schools that there is no planned explicit instruction on gender identity and sexual orientation in the elementary school, isn't there? Using the storybooks and otherwise. The board's policies, moreover, mandate no student or adult will be asked to change how they feel about issues about gender identity and sexual orientation. And if a child does not agree with or understand another student's gender identity or expression or sexuality, they do not have to change how they feel about it. Yeah, but other parts of the material say other things, to be honest. Before the school district introduced the books into the classroom, the board provided guidance to teachers on how to respond to questions. The guidance focused on encouraging mutual tolerance and respect for all those in the community. Take one example. If a child says that being gay, lesbian, queer is wrong and not allowed in their religion, the guidance suggests that the teacher could respond by saying, "I understand that's what you believe, but not everyone believes that. We don't have to understand or support a person's identity to treat them with respect and kindness. School is a place where we learn to work regardless of our differences. In any community, we'll always find people with beliefs different from our own, and that's okay. We can still show them respect. The guidance also directs teachers to discourage the use of language that could be hurtful to students in class. If a student says that's so gay, for instance, the guidance suggests the teacher may respond by saying, regardless of how it's intended, using gay to describe something negative reflects a long history of prejudice against LGBTQ people. So please don't use it in that way. During the first year of the storybook's inclusion in the program, the school district permitted parents, through agreements with schools, to opt out. Parents began making individualized requests. Although some requests were religious, many were not. In March 2023, the board met with a small group of principals and learned that teachers could not accommodate the opt-out requests without causing significant disruption to the classroom environment. Well, then maybe don't teach those materials then. The board also worried that permitting some students to leave the class whenever a teacher brought out students featuring LGBTQ characters could expose LGBTQ students and those with parents to social stigma and isolation. The school district therefore announced it would no longer permit the opt-out. The school district regulations established a multi-level appeal process for parents to challenge the appropriateness of this instruction. Parents can first raise objection at the school level. If that's unsuccessful, parents can raise appeal to the head of the district's evaluation selection unit, who must appoint an ad hoc committee of library media specialists, teachers, principals, and other staff to reevaluate. The committee makes a recommendation to the associate superintendent for instruction and program development, who herself considers the appropriateness of relevant instruction material and renders a decision. If the parents are still unsatisfied, they may appeal to the superintendent of schools, and then the board itself, pursuant to extensive county regulations. Yeah, but if they all tell you to go fuck yourself, then what? You know, right? Are we still live? No. No, we're not live. No. 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 Rather than speaking of which, were there any questions that came in? I should be checking my question thing from time to time because that's why it exists. Does the court have a working definition of the term obscene? Yes. It is in a case called Jones, I think. But yeah, there is a working definition of obscene for adults at least. It is material that appeals to the prurient interest and does not have significant artistic, scientific, literary, or social value. I think. Something like that. Yeah. Rather than avail themselves of the district established process for challenging the materials, they sued. Using the storybooks in English class without parental notice, the parents argued violates their free expression rights. More specifically, petitioners object to exposing their son to activities in curriculum on sex, sexuality, and gender that undermine Islamic teaching on the subject. They worry that reading the storybooks and engaging in related decisions would confuse their son's religious upbringing and undermine their efforts to raise their son in accordance with their faith. Chris and Melissa Persack likewise object to exposing their children to viewpoints on sex, sexuality, and gender that contradict Catholic teaching. Jeff and Sivlanta Roman similarly believe their teachers should not teach principles about sexuality that conflict with their religious beliefs. Petitioners asked district court to enjoin the school district from denying them notice and opportunity to opt out their children or discussing the school books or any other instruction related to family life or human sexuality that violates their religious beliefs. After an evidentiary hearing, the district court denied the injunction. The Fourth Circuit affirmed. It held that petitioners had failed to establish the board directly or indirectly pressured them or their children to abandon their beliefs or affirmatively act contrary to those beliefs in a way this court precedents require. The Free Exercise Clause commands the government shall make no law prohibiting exercise of speech. The crucial word in the constitutional text is prohibit, for it makes clear the free exercise is written in terms of what the government cannot do, not in terms of what the individual can extract. It follows from the text that the Free Exercise Clause does not require the government itself to behave in ways the individual believes will further his or her spiritual development. Instead, the clause prohibits the government from compelling individuals, whether directly or indirectly, to give up or violate their beliefs. Consistent with these long-standing principles, this court has made clear that mere exposure to objectionable ideas does not give rise to a free expression claim. That makes sense. Simply being exposed to belief contrary to your own does not prohibit the Free Exercise Clause, nor is mere offense relate to causation. Constitution does not thus guarantee a right to entirely avoid ideas in which they disagree. There's no public school exception to these principles. The court decision. And blah, blah, blah. So well-established principles resolve the case. Yeah, that bullshit. I think I want to do like an edited story on some of these Supreme Court cases. Let's try to do like a video about them. So I think I'm going to try to put together a script and try to record something, maybe with like graphics from the book or something as part of the story. But I think that's enough for now because I'm a little tired. It's 3 hours. I'm tired. So is there anything more before we call it a day? Thank you for the super chats that came in. Kathy, a lot's been a member for 5 months. Thank you for that. Yeah. Read it while wearing an Aunt Bev wig. Good review. Thanks. Thanks for live streams. Thanks. Yeah, I'm tired. I need a break. All right. So I'm going to sign off and think about trying to put together some sort of edited video or something and go from there. But I appreciate you spending some time with me. I've been on Civil Law. Until later, my friends. I hope all's well. Cheers for now.